Yes.
Wait. I beg to mention item number 43, hearing matter. Can it take it up sometime next week, man?
It's 10 months.
10 months.
You are on bail.
I'm on bail.
And in that case, up to 2 weeks,
Then there are 3 weeks.
3 weeks. On the prayer, Mr. Deepang will consent for the appellant that this matter be listed after 3 weeks.
So I like to mention one unlisted bail matter.
Tomorrow. Anticipatory.
No, Your Honor.
Tomorrow.
The notice to be issued, Your Honor.
Tomorrow.
Matter was filed yesterday.
No, that's why it's urgent. We'll take it up tomorrow.
Please, if my lordship permits, I may be allowed to move one unlisted criminal petition laws
Why? Tomorrow.
of license.
There's no urgency. Criminal petition. No urgency. Tomorrow.
Lordship, I would mention item number 21.
Hmm.
This matter was supposed to list in admission hearing. So, kindly, this matter may be listed on November after 2 weeks,
21.
21.
It's a similar matter or what?
Similar matter is similar matter. So
Item,
we have already filed a reply in affidavit.
item 21.
21.
This is, I think it's a
Contempt.
contempt. Must be court number 2, court number 1. Item 21 is something different.
Lordship, I beg to mention item number 16, 17, and 19 to 33, Your Honor. Lordship, this is all connected matter.
Item
Item number 16 and 17 and 19 to 32, except for 18.
yes.
Your counsel, Mr. P, when leading counsel is
16, 17, 19 to
32, Lordship.
32.
Yes, Lordship, may
What-
because Lordship, the conducting counsel, Mr. P. Yobin is having personal difficulties, so he couldn't.
Why this has been listed? What is for IA?
This is not I, Your Honor. This is
No, the IAs are
yes,
listed.
yes, Lordship. Yes, Lord.
What's this?
This is regarding the stay of the criminal proceedings, Your Honor.
Huh?
Stay of the criminal proceedings, Your Honor.
What do you want?
Your Honor, let this matter be kindly fixed on
On
6
the
November.
prayer of Mr.
G. Yobin, Lordship.
G. Obin, learned counsel for the. You are Mr.
G. Yobin.
G. Obin,
Yes.
learned counsel for the petitioner. Applicant petitioner. Let these matters be listed after
6th November, Lordship.
4 weeks.
6th November, because the counsel will be coming from Meghalaya, Lordship.
From where?
Meghalaya, Lordship.
Meghalaya.
Yes, Lordship may be kindly fixed on 6th.
6th November. Huh?
Obliged, Your Honor, deeply obliged.
Your Lordship, I'd like to mention item number 12 on behalf of the conducting counsel, Tony Patin, for the petitioner.
Yes, on the prayer of so.
Your Lordship, the conducting counsel,
Learned counsel for the petitioner list this matter after 2 weeks.
1 week, Your Lordship.
2 weeks.
2 weeks.
May I, Lordship?
Yes.
I beg to mention one unlisted matter. AB 107.
Tomorrow.
Yes.
Tomorrow.
Yes.
Take it up tomorrow.
Okay.
Tomorrow. Have you filed?
I have already
Is it
filed.
process
Last
of
occasion.
filing.
No. Your Lordship, last occasion matter was listed 2409. But in absence of petitioner, matter could not be taken. So the matter was adjourned. So therefore, I beg my humble prayers.
You are for?
I'm for the petitioner
Why it was adjourned?
because the main counsel was absent.
So after a week, next week,
The counsel is coming from the
next week. Next week.
problem.
Your Lordship, I beg to mention item number 10, Your Lordship. Your Lordship, I on behalf of senior counsel Vikas Sharma.
Hmm.
Yes, he is in Guwahati, and due to his personal difficulty, he
On
could
the
not.
ground that Mr. B. Sharma, learned counsel for the petitioner has some personal difficulty today. Come on, Mr. So and so, learned counsel for the, learned appearing on his behalf, praise for listing of the matter after 2 weeks. Prayer is allowed, list after 2 weeks.
Mashallah.
Lordship, item number 9. It's
Hmm.
not a matter adjourned, it's, by the rejoined action.
On the prayer of Mr. Item 9, T. Tapak, learned counsel for the petitioner. List this matter after 2 weeks so as to enable him to file affidavit in reply.
Reply. And one more adjournment, one more, that is, item number 40.
40.
Yes, 40. Matter may be allowed to withdraw, with a legal contract. No, you can order court of action, say,
Criminal petition. Why liberty is required?
Suppose, the application is, down for filing, this, criminal petition.
Okay, Mr. Chief Land Counsel for the petitioner submits that he may be allowed to withdraw this this petition with the liberty to file a fresh. Praise the Lord. Criminal petition is then dismissed and disposed of on withdrawn with a liberty as per.
Lordship, I'd like to mention item 39.
Hmm.
This matter may be listed after 2 weeks, Lordship. Because AK going from Guwahati could not appear today. Criminal petitions also.
On the prayer, Mr. K. Land Counsel for the petition list this matter after 2 weeks.
There is an interim order,
Interim order passed years and continue.
quickly obliged.
Item number 1.
My place, Lordship. Lordship, by filing the civil revision petition, the petitioner is challenging the impugned Kaba order.
Where is about that?
Kaba order annexure 1, Lordship, page 26. There is a grave procedural lapses, Lordship. What happened, Lordship? The background of the case is that the petitioner number 2 is having a plot of land at Basar area. Petitioner number 1, 2. And he has authorized petitioner number 1 to look after his land. That in the meantime, Lordship, the respondent number 2 has purchased plot of land, 400 square meters of land from the petitioner number 2. An amount was also paid. An amount was executed in between, money receipt was executed in between petitioner number 1, he being the authorized agent of petitioner number 2, and the respondent number 2. But complaint was lodged by the respondent number 1 also.
Who is?
He is the son of the respondent number 2.
Okay. So,
Now, Kabang was held.
hmm,
And before Kaba, the petitioner number 2 has filed his reply. He was, in fact, not made as a party in the Kaba.
petition number 2.
2. He's the actual landowner, petitioner number 2.
It's okay.
He specifically,
Petition number 1 was there.
1 was there.
Then
But-
execution was between the
1,
sale deed was executed between the receipt or whatever is being paid between the petition number 1 and 2.
1 and respondent number 2.
Yes.
Yes. The complaint has to be how the respondent number 1, though he is the son, but how he can agree by that. Now the complaint has been lodged saying that the land sold by petitioner number 1 does not exist. It is his complaint before the Kaba authority.
Hmm.
Now on receipt of the Farwana, the petitioner number 2, the actual landowner, he has submitted file reply also, though he was not made as a party, admitting that yes, my plot of land was sold to respondent number 2, and still it is exist, and the money receipt was also executed in between petitioner number 1 and respondent 2. I have received the money and the money receipt also. Despite of that, Your Honor, Kaba was held.
Where is
with-
this money received? Where
Money-
is the transaction?
Yes, transaction, page number 33. 33 Lordship.
This is money receipt.
Yes, money receipt, Lordship.
Where is the sale date? Any agreement
No sale deed, Lordship.
when? Place pushing your insurance, receive the amount of rupees, so. Only being.
Only being the cost of road measuring, yes, Degam area of Godi tree from Mangam Basar. She is the respondent number to actual who purchased the land. She has not any agree in terms of the complaint. But she was not before the Kaba.
So
Now complaint, Lordship, may take you to the complaint filed by the respondent number 1.
it's on factual matter, factual basis. Where is the jurisdictional issue?
Jurisdictional, Lordship, it is the respondent number 2 who has purchased the land, whatever the money received executed. If she agreed, she has to approve the Kaba authority, not by the respondent number 1.
So that's why I'm asking you, who is? Who is respondent number 1?
Is the son of respondent number 2, Lordship.
How old she is? Respondent number 2.
Age is not mentioned anywhere, Lordship.
And the son has the son or daughter? Son.
Son,
Son has the right.
Lordship, but without any authorization, Lordship.
What
And-
authorization?
But
Is-
Lordship, complaint, Lordship, my Lordship may see the complaint, contents of the complaint.
He's the son of respondent number 2.
Son, but he has not been authorized. And the complaint, Lordship,
No,
may take-
son doesn't need any authorization. Unless you say that they don't have a relationship.
but here, Lordship, at least the respondent 1 and petitioner number 2 has to be heard by the Kaba. Because now the complaint is there,
Respondent number?
respondent number 2 who purchased the land and the petitioner number 2 landowner, actual landowner. Now complaint is there, the petitioner number 1 has entered money receipt with respondent number 2.
You have been authorized, respondent number, petition
Yes,
number,
authorized.
you have acted on the principle.
Yes, Lordship. That's right.
Doesn't matter, you have represented everything.
But
You are there,
yes, Lordship.
you are there in the Keba.
Yes, I was there. And their land is there, Lordship.
That's a factual matter, we don't know. That's why I'm asking, what's the jurisdictional issue?
Jurisdictional, Lordship, without hearing the petitioner number 2 and the respondent
Doesn't
number
matter.
2.
The
Now they are saying that, Lordship,
transaction is between you and the respondent number 2.
yes, Lordship.
Respondent number 1 made a complaint being a son of respondent number 2.
Yes.
What's wrong there?
Saying in his complaint, he is saying that the land sold by petitioner number 1 does not exist. The first point. Thereby, the
That's why I'm saying it's a factual matter. Whether it's exists
Lordship-
or not, that's why I'm not concerned.
Lordship, but Lordship may see the infine order, Kaba decision, Lordship.
Yes.
Kaba decision, now they are saying that operative person, Lordship, type copy,
Page
page
29.
28. Lordship, yes, 29.
Yes.
Last para, Lordship. Today on dated 23/9/2025, the Kaba was held and after hearing both the parties at length, Kaba passed the following decision. In money receipt, there is no mention of name of the landowner. Lordship, the petitioner number 1 is the authorized agent. And
You
that-
read the first para.
the complaint series so and so
Hmm.
on 20th May came to the house of Sri so and so GB and filed a complaint against Sri so and so of Pusinyorak Blaze, West Central District, alleging that both came to his residence and offered to sell a plot of land from Rugen area for an amount of 12,40,000 to the complainant. Complainant, this is also wrong, Lordship. The land was sold to the respondent too.
Purport to say.
And accordingly, mother of complainant so-and-so paid the said amount in presence of brother and father as witnesses, and money receipt was also given. And later, the complainant got to know that Rugen land does not exist. This is the first ground of their complaint. The land does not exist. And after knowing that complainant Sri so-and-so asked the seller to return the money of his mother amounting to so-and-so. Now, he's alleging that lordship, the amount was received thereafter. They came to know that the land does not exist. This is not factually correct. This fact has to be ascertained, clarified if both the parties to be heard by the Kaba authority. Your Honor.
In that case, you file an appeal.
Appeal lordship, without hearing the parties, they have committed the grave lapses, procedural lapses. At least petitioner number 2, the landowner, he had on receipt of forerunner, he has also filed the reply.
So this is civil revision petition.
Yes.
Revision in jurisdiction. That's why I'm asking, where's the jurisdictional issue? Whether the land exists or not, and you being acted as the agent of your principal, you have to show.
Lordship, the reply
Did
was,
you say that the land exists?
yes.
Then you file an appeal, not revision.
Lordship, since without hearing the necessary parties.
No, it's not necessary. Because you are the agent.
Yes,
You have been authorized
Yes.
to purchase and transact.
yes,
That you have done.
yes,
Now the son of the purchaser
yes,
is saying that the land doesn't exist.
exist.
So you have to return. So you might have said that land exists. Whether it exists or not, I mean, it's a matter of appeal.
Lordship, petitioner
You are
number
not
2, they filed his reply before the Kaba also, Lordship. Landowner. They take it to phase 41, Lordship.
I'm not inclined. It's not a case of revision.
At least
41.
the parties who agree has to approach the Kaba. It's not,
See,
if son has approached the Kaba authority,
others, I mean, son and mother doesn't have the relationship.
yes, relation.
Then
But he's misleading the Kabang authority by the respondent number 1, Your Honor, saying that the land does not exist. Now the petitioner number 2, who is the actual landowner, he filed his reply to the Kaba authority, though he was not made as a party, where he admitted the fact that yes, my agent, that is petitioner number 1, has sold the plot of land to the respondent number 2, and land is dear, and there is no any dispute over the plot of land purchased by respondent number 2. Page 42 also, we specifically admitted the fact, if anyone is disputing the land purchased by so and so,
in fact, Mobley has purchased. He being the government servant,
yes,
money was paid to his mother, paid to his
yes,
mother.
mother, and money receipt was executed in the name of
Huh.
his mother.
So what's the question of, he's a de facto.
Yes, on record, Lordship.
He's a party. He's the one who has purchased. But
Yes.
just because on your own showing, it was purchased by respondent number 1,
Yes,
he being a government servant, money was, I mean, the transaction money received was, and the payment was on
Yes.
behalf of his mother.
yes, Lordship. But on record, Lordship, the money receipt executed.
Mother is a de jure.
Yes, but their complaint, Lordship, they are saying that land does not exist. Because of that complaint, that
How do you decide that, whether they exist or not? You file an appeal.
but without hearing, Lordship, they have directed.
Whom?
Petitioner,
Mr. Mobley was there, you were there.
petitioner number 2, Lordship,
Petition number is not required.
actual landowner.
You have acted on behalf of, you have been authorized, you have acted as an agent. Petition number 2 is only the principal.
Yes,
Anyway,
but tomorrow,
heard
Lordship,
Mr. K. Lowell, learned counsel for the petitioners. Claimed to be aggrieved of the Kaba decision dated 21/09/2025.
23, Lordship,
Huh?
Kaba decision, 23.
Page 29, you said it's written 29.
29, Lordship, they wrongly reflected, but Kaba was passed down below, Lordship. All the GB chairman, everything, Kaba members, they put their signature. Well,
Okay. 2309, 2025, passed by the village authorities oblique
Gori Blaze customary.
Of oblique Gabura of Gori village. Two, huh?
Yes.
Gori two,
Gori
da-
two.
dash, Raman two, sorry, Raman two village. Whereby the money, sum of rupees, 12 lakhs 40,000, which was paid to the petitioner, respond number two by petitioner on behalf of petitioner number one on behalf of petitioner number two for the cost of land measuring 400 square meter at where?
At the
Rugen area of Basar,
Yes.
in the district of
Lep-
Lord's Leparata,
Leparat.
to be returned back within a period of 1 month. Please stop. It is the contention of land council for the petitioners that the Keba decision, the Keba has arrived in a wrong decision without hearing the petition number two, who has actually purchased the land,
Respondent number two.
and the respondent number two, from whom the land has been purchased. Therefore, without hearing the necessary parties, the Keba has committed a jurisdictional error in deciding the issue merely on the basis of the complaint lodged by the petitioner respondent number one, who happens to be the who is the son of respondent number two. Should I record my findings which I have come across?
Regarding reflect.
On yes, your reply page 41. You have the respondent one is the one who has purchased, in fact.
Yes, Lordship.
Is it
Because
defect
that
of
is the fact, factual, because
issue notice returnable by 4 weeks. London Council for the petitioners to take steps to service of notice upon respondent number. For take steps for respondents register for so and so, within 2 days from today. That's all.
Lordship, government order is suspended because tomorrow is the last date. 30 is expired tomorrow.
In fact, I'm not inclined. It's the revision doesn't lie. Anyway, till the returnable date, the Keba decision dated 23 so and so, 23/9/2025 shall not be given effect. The respondents are at liberty. Since the Mr. Next para, huh? Since the interim order is passed in the absence of, without hearing the respondents, the respondents are at liberty to approach this court for modification, alteration, if so advised. Considering that the matter may, considering that prima facie the issue, the matter may be a case of appeal. Pendency of this, the revision petition shall not be barred to the petitioner to take a call the issue as observed prima facie by this court hearing above.
Item number 2,
My lord, this matter may be withdrawn.
Huh?
Matter may be withdrawn, my lord.
Why?
Some technicalities in the petition.
Mr. Item 2,
Item number 2, my lord.
bail application.
Yes, my lord.
Mr.
M.
M. Pertin Junior, learned counsel for the petitioner. Submits that. Your name is not there?
Yes, my lord. I'm appearing on behalf of D. Riba.
T. Riba is also not there.
D. Riba is there, my lord.
Oh,
Takjum Riba.
okay. Mr. M. Pertin, learned counsel for the petition, the counsel appearing on behalf of Mr. D. Riba, learned counsel for the applicant. Submits that he may be allowed to withdraw this bail application.
With the liberty to file fresh. sir.
To file a fresh.
No problem.
Mr. T. at the learned additional please. The petition is, the prayer for the legal officer. The liberty to, Mr. According to the penalty states, dismiss on withdrawal with the liberty as well. Dispose of, or close.
item number 3,
Page number 7,
Rejected by whom?
rejected by the accessor.
Hmm.
Special judge and the PS sponsor.
Heard Mr. So-and-so learned counsel for the applicant. This is an application under section 483 of PNSS 2023. Praying for grant of bail to the accused person, namely Sri Tingang Si Kongkang, in connection with what is case?
Sponsor PS case.
Onsa PS case number 13 of 2020 under section 17 within bracket C, bracket close of NDPS Act. Call for the scan copy of case diary. Case diary. Mr. Stern's, theater and edition. Just, which on behalf of Mr. List after
2
2
weeks.
weeks.
Of license.
item number 4,
Why not, your, there's no name,
Yes, my name was not shown.
why?
Other advocates are also there, my lord, but my name is not last.
Your, no, none of the
No, I have
Advocate-
signed the Wakalatnama.
are shown. I'm just asking,
Yes,
you find your power.
yes, I have.
Okay. So,
My lord, it's a period bail application, my lord.
Hmm.
Allegation is under section 318, in bracket 4 and
Hmm.
316, it is sitting and impersonation. I had not named in the FIR.
Hmm.
But when, my lord, the main accused, one Keshav Gogoi, was arrested, he impersonated and sold an excavator to the informant. And I have to get payment from the main accused. He gave me one check of rupees 1 lakh to encase. I have encased that in my account. Before submitting to the bank also, I have called whether I will encase or not. This I have clearly stated in paragraph 4 of paragraph 3. This is the allegation against me. I am apprehended only because that the police is asking me to appear before the IO, that is annex of 4, page 4. I will appear, my lord.
When you were,
Within 1 week, my lord.
when you were asked to directed to appear,
It was, my lord, asked to appear on 14/9/2024.
then
That time,
today is what?
yes, my lord,
Today is what?
today's time, of course, October. I may be given 1 week time, my lord, I will appear.
Yes, madam.
I will appear, I will report my.
Lordship, in the recent judgment, Lordship, every Lordship AB should be filed before the appropriate
There's no recent judgment, there's a judgment, but then it has been under consideration. That was a prime facie view.
Yes, Lordship.
There was a view of the division bench of this court, and the Honorable Supreme Court is inclined to that.
Yes, Lordship.
There is a amicus have been appointed. They have given their note. It's other consideration.
Yes.
It is yet to be settled. So
And then Lordship,
why don't you approach the sessions?
My lord, he is from Assam, my lord, because he is apprehended to go in there.
Where?
Patsigat is. Session Court.
Where?
He is apprehended, my lord. He may be-
It's a case of where?
It's a case of
Patsigat.
Patsigat.
Okay.
Upper Siang.
first
And
supposed
at
to
the
be,
same time, it's not, see, madam,
Taliha.
yes, Mr. Pipi. It's not absolute bar. The note has been prepared. The Honorable Supreme Court is, I mean, prior procedure that they should be, first they should approach, but it's not absolute. They have to show that why, I mean, they cannot approach. There's a rider, I mean, there's a condition also. It's not absolute that the High Court cannot take up the matter. You have to. Has not been decided. It has been decided. Thereafter. Yes, yes. No, now Supreme Court is, it's under consideration. The amicus have been appointed. They have given their opinion, I mean, the suggestions by filing a note, and it's under consideration. It was listed, I think, last week. Matter was listed last week before Honorable Supreme Court. So what do we say? You have no sessions court,
No, my lord, till then I may be granted. I will appear and I will report.
not appear. But they are saying that no,
No,
you
they
should
did not-
approach the, unless you can show that you are handicapped or something like, you cannot
No, he is
approach the
from-
sessions court.
the petitioner is from my lord Demaji, my lord.
This is very difficult.
Yes.
You being not a native of Arunachal Pradesh,
He is
once
from
the bail is
Silapata.
granted,
No, he is from Silapata, my lord. From my state of Silapata.
you are saying Demaji?
Demaji is come under Assam.
Okay.
Silapata come under Assam.
We'll see. For a time being, we'll entertain because he said the police are from Pasigat.
the Paksikat also is a PS Taliha Upper Supposedly.
Yeah,
Upper Subansuri.
so. Yeah, but the sessions court.
Session Lordship is in zero Lordship.
Thalia PS case, you'll not be arrested. You go to zero.
My lord. So in the meantime, I will report my statement, my lord, only apprehension that I am going there.
No, it's not a question of that. But inclined, but the problem is that they are raising that normally you have seen, you have checked it. Supreme Court is also privacy view that it has not been settled as yet. But they say that normally you should approach the
Yes, that is
sessions.
sessions order.
It should be in Basar Lordship, not zero.
Okay.
Jurisdiction in Basar.
Upper Subansuri.
Yes. What do you say?
Lordship, if it's under construction, then Lord,
Let us see. Heard Mr. S.K. Devi, learned counsel for the applicant. By filing this application under section 482 of BNSS 2023. About the applicant seeks for privilege of pre-arrest bail in connection with what? Thalia PS case number 09 of 2020-25 under section 318 within bracket 4/316 within bracket 2 of BNS 2023. Call for the scanned copy of the case then. MS El Hage Land Edition PP. And this accepts notice on behalf of the state. Having considered that the having considered the submissions of and counsel for the petition applicant that the petition the applicant is has no direct link with the offense alleged and the and also that and also considering that he has not been named in the FIR in the interim and in the interim in the event of arrest, the petitioner shall be the applicant shall be released on applicant's reassurance shall be released on bail furnishing it bail one of the reassurance rupees 20,000 and with two sureties following conditions. The applicant accused shall appear before the investigating officer on when will give the fix there
Case study may be called for on 29, then before that.
For that, within 1 week, I will appear.
on 27 1/0/2025. Then you write the petitioner shall not sign in view signs two other conditions. List the matter on 29. Then
Apply.
Matter number 5,
May I please?
yes.
Proceed. This is out of same cause of action, my lord. The multiple FIR has been filed, my lord, against the petitioner. My lord, some other accused person, not the petitioner. Now here the same my lord, cause of action and FIR is my lord, basically against one my lord, space number.
Same cause of action. Why different FIR?
My lord, that is that's as per the center, my lord. Yesterday's matter was
The exam was for the same recruitment was for
yes, madam.
same post,
Same post, madam.
same department.
Separate center, madam.
Where is the last order? Have you annexed this? Have you annexed the last order, the order in the other case?
No, madam, just I have made a statement, madam, paragraph, madam.
Not Mr. When the matter is fixed,
28, madam.
28. When you are supposed to appear,
On 24, madam.
24.
Yes, madam.
You appear on 24
Yes, madam.
or 25?
24, madam.
No, when you are, can you appear? It's the same investigative.
Same investigation.
Huh?
No,
Same IO.
Station is different
different police station.
Then how can you appear on the same day?
on 25.
25 is Saturday.
Yes, no, sir.
Can you appear?
Yes.
Saturday?
Yes.
Or Monday, since the matter is listed on.
Monday.
Heard Mr. M. Kato, then counsel for the petitioner. Accused applicant. This is an application under section 482 of PNSS 2023. Praying for grant of prayer respect Grant of privilege of pre-arrest. Pre-arrest in connection with Chimpu PS case number 34 of 2020 under section 61 in the 318(4) of the BNS 2023. Read section. You just take page 1, page 1 and 2. Technology Act 2000, call for the case, scan copy of the case there. Mr. D. Lloyd, and public prosecutors. At least for this state. Then same order on 25 appear on 20. You give that, what is that order? Same, huh?
Yes.
Allegation same, only it's a different examination, a different examination.
Same examination, Lordship.
Examination
Yeah,
center,
center is different.
center is different, police station is different.
Yes, Lordship.
Police station same.
No, different police station.
Earlier one is Ithanol PS,
Niti Bihan.
ETB.
This is simple, madam.
Okay. Then you can appear on 24.
Yes, ma'am.
What do you say?
Yes.
Or 27?
Any that Lordship.
Well, since I am coming from the other state, so on 24 will be madam the appropriate.
We don't know. On 29, we may reject the bail application also.
True,
You'll be here till 29.
Till then,
Ask your client to be here for till 29.
but then my
Appears to be you are the kingpin of the entire
I'll,
racket.
I'll appear before the IO of the Malad on 24, my lord.
24. Huh?
My lord.
List on 29.
Yes.
29.
My lord.
No, 28 Lordship.
Huh?
On 28.
No,
Wait.
other cases is listed
Yeah.
on
28, my
20 and then 28. Be here.
Yep.
lord.
Item number 6.
My lord.
Yes.
My lord, respectively submitted that this present petition is incomplete and defective.
Otherwise, it's not, you will dismiss it.
No.
What is the offense?
No, there are some, after reading the agreement and document, there are some paragraph are not submitted. And also, we are filing for the quashing of this petition.
Well, question of which offense?
My lord, we have given respondent as a wife, which is not defined under the
It's
definition.
a
of-
maintenance,
Yes.
125.
Yes, the main case was maintenance, and we are.
We are
quashing for
not
the-
allowing you to withdraw. Will dismiss the petition. You are paying are you paying the interim
Yes.
maintenance?
Yes, ma'am.
You keep paying. You agitate before the appropriate court. I mean, judicial magistrate first class. It's not a case of quashing.
But my lord, please give me a second chance that we can bring more documents with.
Nothing. Anyway, but properly advise your client. You fight it out in the maintenance court. All right,
Okay.
not quashing. It will be useless, futile exercise. Your energy, and it may be misdirect you in your future career. Maybe case of misdirection. It's not healthy for you. Anyway, MS so-and-so, learned your MS
G Mamu, Gimi Mamu,
Gimi
Mamu.
G. Mamu,
Yes.
learned counsel appearing on behalf of Mr. T.
Yeah,
Toru.
Itorom.
Learned counsel for the petitioner submits that she may be allowed to withdraw this criminal petition. That's all.
Right, right.
That's all.
Yes.
You want to file again
With liberty, Your Honor.
with a
Please
liberty,
allow to file with
with a
liberty.
liberty to file fresh list of. I'm not observing anything, but then we'll just simply allow, but think about it. Reflect yourself,
Yes.
go through the, provision.
Okay, ma'am.
Tell your senior also. Where is Tarum? Yes. How can we, what's the 125 maintenance?
In fact,
You can-
125 CRPC given maintenance to the web, but in fact here,
It's all,
Again-
you read it again, sir. Read it again.
that's why we,
I read it yesterday only.
that's why we are asking for,
Please read it again. All right. Hopefully you will not file again. Better to fight it out there in the appropriate court. All right? With a liberty to file fresh. Prayer for withdrawal is allowed. Accordingly, the criminal petition stands closed on withdrawal with a liberty. With a liberty as prayed for. Yes. With a hope and trust that Mr. Torum will not come back in the same with the same petition. Okay.
Yes, madam. Obliging.
Item number 7.
What is this, sir?
Well, I'm challenging the order at 10/6/25.
Hmm.
Is at page 46. But the trial court on the basis of the application filed by the IOA, without application of mine, Malad state you issued the non-bailable warrant of arrest. Page 46 is the order. So it's at page 44.
Praying for issue of non-malware against accused, namely Ajay Bahadur Singh from Guwahati, Assam on the ground. He is not cooperating when the investigation is about to participate in the investigation. What's wrong, sir?
Malad, we find even in the Malad, application for issuance of the non-bailable warrant,
Hmm.
the IO himself has said, Malad, I appeared, my statements have been recorded. Everything is there, Malad.
No, you are not cooperating.
But there's no summons or there's no call from the IO, Malad.
Hmm.
Had he, Malad, would have called, Malad, I would have definitely, Malad, made available myself, Malad. So far as this direct, Malad, issuance of, so therefore, Malad, the court below, Malad, ought to have, Malad, considered the actual materials, Malad. Why, Malad, the mayor summons or by, Malad, bailable warrant of arrest would not have served the purpose. Merely because the IO has been saying that I have not been cooperating, while the record appears, Malad,
Now, why don't you file for a recalling of this NBA?
Malad, my
You approve
prayer,
it?
my prayer is, well, my prayer is for setting aside that order.
No, that's what I'm saying. You may go back to the CJM for recalling this order. NBA.
With all respect, perhaps that court would not have the jurisdiction to recall his own order.
No, an NBA there can be recalled also.
So this, unless this order is set aside, Malad,
It's only the available warrant is to be recalled. Can be recalled.
this is non-bailable, Malad,
No, that's what I'm saying.
not.
What do you say? It's a available warrant only. It is NBA only. It can be recalled.
But this court has the power to recall, Malad.
Not this court.
Not.
The same court who has issued the warrant.
That the unless this order,
Yes, madam.
unless this order is
His
Malad,
lordship
reviewed.
he pointed out that he may file the recording.
Where is the provision? Where is the PP?
Lordship,
Where is the provision? Under which provision?
the lordship 311 of CRPC lordship.
Huh?
311 of CRPC.
111 or CRP. Now,
Lordship, now.
what's CRP? BNSS. Now BNSS. Right. Section?
Okay.
Sir, we'll take it after some time. If you are not inconvenient. Go through it, please.
Lordship.
Go through it.
My submission is unless the
Let us,
order.
let us, to be frank, let us
Lordship,
learn together.
Lordship.
Yes, find it out.
I'll check it.
Item number 8.
May I please, your lordship?
Yes.
I filed this criminal petition regarding the quashing the criminal miss case 174 public 25 before the Honorable JMFC UPA, invoking the 528 of BNSS provisions.
What is
Lord-
the offense?
Offenses sections 318 subclause 2, 3, 4, section 316 subclause 2, 319 subclause 2, 336 subclause 4, 3, 5 subclause 5. This is a cheating subsections, breach of trust and common intention regarding the matter. But matter is purely in civil in nature regarding the some business transaction between the fact is this, my lord. First of all, I come sequence wise.
No, according to them, according to the complainant, you have fraudulently used the, what is called?
GST number.
GST number to obtain, I mean, to get the flight tickets.
This is
That
the
is
allegation.
knowledge. That the knowledge of the complainant.
But fact is different, my lord. First of all, my lord,
So it's a matter of trial. The facts are different.
my lord. First of all,
Anyway, well, issue notice.
Lordship, I'll just
Yes.
bring your lordship notice that in the petition, since they are challenging the complaint itself, your lordship, the petition does not contain the complaint petition itself. Also,
What?
the agreement, your lordship, since
Where is the complaint?
my lord, due to some personal difficulties, the enclosed, the complaint petition is not enclosed here. To
Where
keep
it is? Do you have the complaint petition?
Yes, my lord.
Do you have the petition, complaint petition?
No, no, no. I'm the accused person on that complaint petition, your honor.
That's why I'm, have you not been punished?
No, no. I filed the CTC copy in the give opportunity so that I file the additional affidavits, file the complaint
You file
petition.
it, take it up tomorrow. What is-
Tomorrow it's
It's better you file, withdraw it and file it today. We'll take it up tomorrow. It should be properly, because we'll have to see what the complaint indicates, I mean, reflects. Is that it?
yes, your
My-
lordship,
You better withdraw and file it fresh. We'll take it up tomorrow or day after. When is the next date fixed?
29 of this month.
Okay, we have enough time. You file a proper petition annexing the complaint,
Complaint petition.
right?
Yes.
All right. What do you
Okay,
say?
Liberty to file a petition.
Mr. M. Bagra,
Bagar.
learned counsel for the petitioners. Having realized that the complaint petition has not been annexed in this criminal petition, submits that he may be allowed to withdraw the present petition, he may be allowed to withdraw the petition with the liberty to file afresh by annexing all the relevant documents, including the complaint.
Complaint petition.
MS so and so. T. the learned edition to the present. Considering the submissions of the learned counsel for the petition, the prayer for withdrawal is accepted. Instead, accordingly, the petition stands closed on withdrawal with the liberty as prayed for.
Depot.
Item number 11.
Yes.
We were supposed to find the speaker's report pending before the Honorable Supreme Court.
What
But
is-
ultimately, this
What
matter,
is the matter?
Mihin Lalni case, my lord, will remember that this is for payment of 100% solution.
So can I take up that matter?
Yes, my lord, this is another thing, my lord. Now, this ultimately, the Honorable Supreme Court has passed the final order
Saying what?
saying that, yes, under the Jumland, even though the Jumland regulation is the acquisition is under that, they will be entitled for 100% solution. However, those cases which ultimately has been concluded by determination and payment, everything, that it will not affect that. It will be in prospective, my lord.
So this is a case of
This is a case,
settled.
settled case, 2017, they have admitted that they have received the payment.
Is it correct?
And then they have filed this writ petition in 2008, 23 after receiving the payment. So paragraph 29, my lord.
In respect of concluded acquisition, which
28,
compensation has
yes.
been finally determined, accepted and dispersed, no reopening shall be permissible. The interim judgment will have the sentence to the extent, to that extent. However, in all matters which remain pending either before the completed or before the court will be compensation shall be recompleted to include solution issues as above. The direction company are interim of the case regarding deposit amounts will be people shall be given to the present solution interest payable. Have been finally determined, accepted and dispersed.
Yes, my lord.
No reopening shall be permissible. The imperial element of the High Court is set aside to that extent. However, in all other matters which remain pending, either before the company or before a tribunal, a court or tribunal means what?
For determination of the compensation, if there is anything pending, still pending for determination of the,
Not
which
the
which has not been concluded, but which has been remained unconcluded for determination of compensation.
What is the interim order?
My lord, here, I believe the
Deposit
state
of
is going
amount.
to, yes, state is going to file a review on this because that interim was with respect to another case where the NHIDCL was, they have accepted to deposit in the interim, they have deposited. That is in pertaining to another case. But in this case, this order has come up.
So in that case, what
Your Lordship, actually, the leading counsel also state out of.
We'll bring this on record, madam.
I think it's better.
Yes,
But you look into this, I think you need to file that.
that
If
review
you are
also,
agree, I think you have to file something. Because it say direction contain order in our interim order, so and so,
That-
deposit of amounts.
yes,
It is
Dep-
something, a different case.
different case. That was, I think, in Jote Yoto case. Where the,
Heard MS Swenso, learn counsel for the petition, who submits the leading counsel, Mr.
Esmo.
Esmo, has some personal difficulty today, therefore he could not appear. No, he's in, the Esmo is indisposed, huh? We stop. Mr. And that will learn additional advocacy by placing the judgment in order. Judgment dated
16,
16,
16-9.
16/9/2025. Passed by the Honorable Supreme Court in the case of the state of Arunachal Pradesh versus Sri and others submits that the issue of solicitation and interest with the issue regarding solicitation and interest in respect of land compensation has been finally settled by the Honorable Supreme Court to the extent that that in respect of concluded acquisition, where compensation has been finally determined, accepted and dispersed, no reopening shall be permissible. Having considered the submissions of learned counsel to the parties, let this matter be listed for further consideration. After 3 weeks,
After
3 weeks,
Yes.
put it here or you'll take it.
But we'll file it in our affidavit also.
You record their name, huh? Are also are present. You also appear, are present. Yes. So ultimately settled.
Ultimately,
Now you will have to
Yes.
But otherwise also now the state has.
The state has already enacted, amended
That
the
they-
Zoom lane
From
regulation.
now onwards,
Yes.
the compensation will include the solution and interest.
That has also been referred here in this chapter.
So,
So
That
now, now onwards, every acquisition, whether
so
in the
that
Zoom
way,
lane
at
regulation,
least the state be in a better wicket now
yes,
by the lapse of time.
omelette.
Item number 13.
Yes, sir.
My lord, I have received, I'm the petitioner. I have received the affidavit in opposition. So I need to file affidavit in reply.
What is
So
the matter?
This is a matter pertaining to the promotion.
To the post of?
uh,
My lord, Assistant Registrar for RGU is challenging the advertisement of the university for recruitment to the post of Assistant Registrar.
Okay.
So there is interim. So we have filed the affidavit that this case doesn't exist. And since we are adopting the model cadre recruitment rule of Central University of 2022, so he is claiming for 2015 our own university recruitment rule, which has been rejected by UGC, and we are adopting the model cadre recruitment rule of Central University.
It's a central university.
Yes, sir. Yes, RGU is a Central University.
So you will follow the UGC regulation.
Yes, Your Honor.
Not you don't have your own recruitment.
No, we don't have. So we have that was rejected by Central University. So he is claiming for 2015 that own university which was rejected by this UGC.
It's no longer there.
No longer. And Supreme Court has very clearly made a judgment in the that is.
Anyway, he said he wants to file it.
yes, I need to file affidavit in reply.
But then you cannot improve your case. This is the basis only.
Yes, Lord.
You are relying on the rule of 2015,
Your Honor,
which is no
my
longer there.
friend submitting something, but recorded saying something.
Yeah.
Yes, UGC instruction already given,
Lordship-
but
Lordship-
RGU is not following the instruction.
Lordship, this 2024.
Anyway,
So
had Mr. Tito Learned Counsel for the petitioner praised for and is granted 2 weeks time to file affidavit. in reply.
Lordship, 1 week. Since
One
they are interim,
week.
because of this interim,
Okay, 1 week.
we are facing problem, not able to recruit.
You file this case if you are agreed. I mean, IA for modification. Anyway, 1 week. Reply, 1 week. Yes. All right. It's a recruitment,
Yes.
1 week. Press one is granted a 1 week time to file affidavit in reply.
Sir.
Mr.
Arnabam,
Arnabam,
Standing Counsel, RGU.
Standing Council. Rajiv Gandhi University
Yes, RGU.
is present.
All right.
Otherwise,
Item number 14.
Challenging the conviction under section 306 amendment of the society. Well, not only before I take my lord to the
It's
fact,
listed for first time.
first step. My lord, can we only, I request my lord only to see the paragraph 101 at page 71 of the impugned order,
71.
conviction order.
Ah.
Now, my lord, it is also alleged in the case of prosecution that both the accused persons, namely so-and-so, had common intention in abating the disease to commit suicide. However, the evidence on record is not sufficient to prove the meeting of mind or common intention of the accused person to abate suicide of the disease. Now, my lord, if I go by the finding of the court,
But
it's
this abate is something different.
abatement. Abatement.
No, this abatement, the spelling is wrong.
That's,
This connotes different thing.
no,
This word is ABAT is a different meaning.
I don't know whether this is the learned trial court have written.
No, that's I'm just saying. Just notice it.
Yes, it's right.
ABAT is something different.
Correct.
It's other way around.
Other way around. Abate is something.
This has to be ABET.
Yes.
ET.
So anyway, typological mistake.
Hmm.
Well, my lord, once the learned trial court finds that there was no meeting of the mind, then a person cannot be convicted under section 306 of the IPC.
Anyway, we'll issue, we'll admit this.
Correct.
Any respondent is there?
One only. The complainant.
Complainant. Take steps for that. We'll admit it. All right.
My lord,
All for
including
the-
usual course also.
Huh?
Including usual course. Normally, it has to be routed through them.
Heard Mr. Tititar, counsel for the appellant. Uh, This is an appeal under section 415 within the two of BNSS 2023. Against the judgment and conviction dated 16/09/2025. And sentence of the dated 17/09/2020 was by the district and session, district, was by the session judge. Pakun Parid, session judge UPI in sessions case number 14 of 2019. In connection with the, it's not sessions case. So,
Yes.
under section 223/306/34 of IPC. Conviction is under what?
306. Abatement of society.
306, huh? Only 306.
Only 306. 223 is also there, but then 360 CRPC can be invoked in such case for good behavior. But here the landed trial court has.
Where is the sentence?
320. The sentence, page 7.
066 IPC, huh?
73%.
Where the appellant.
Para 11, page 75.
Only you,
Yes, sir.
whereby the appellant is sentenced to undergo rigorous imprisonment for 10 years with payment of fine of rupees 10,000. In section 306 IPC. (323) also. It says in there, under section
1 year only.
323.
323.
Oblique 306, huh? Then you write the sentence for another 10 years, same, huh?
Well,
And,
paragraph
and
11.
1 year for under section, 1 year
320.
for the offense under section 323. With a default stipulation to undergo simple imprisonment 2 months. Which shall run concurrently. Admit the appeal. It says admit, huh? Call for the trial court reports, no? MS El Hagi Alan with additional PP. And this appearance on
There is an IA for suspension of the sentence.
so,
But there is
the learned counsel for the appellant to take steps for service and not to happen. Respond number 2.
Correct.
Registered post as well as usual process. Next para. In IA, you write issue notice.
extreme
Same.
short date, my lord.
Same, huh? This is an application for so and so, so and so. Check it out. No, you have to take steps here also.
I'll take, my lord.
This is 430, huh? BNSS. Seeking suspension of sentence, huh? In in Sessions case so and so, in the connected appeal so and so, huh? Are you getting it? You take his steps. MS so and so, same, huh? Addition 2P, you take his steps, respond number 2.
My lord has seen Prabhapasai,
Issue, in that case, issue notice, huh? Just after 2 weeks. 2 weeks.
correct, 2 weeks. I'm grateful.
Item number 15.
But you have to take steps.
Lordship, this case, I have, today I have filed the reply.
Yeah.
Fix for,
Although office note dated 21/10/2025 indicates that no rejoinder has affidavit has been filed, comma, Mr. T. Tapper, land counsel for the petition submits that he has filed the affidavit in the plate today. You have,
Received just now.
you have received.
Yes.
To which, MS G at the Leonard additional senior government advocates. Submits, has received. Has already. And the same has already been furnished to the Leonard additional senior government advocate, Mr. G, MSG at the. Then
6 for admission.
what is the matter?
Regarding this, service net. Termination profile.
It's already in this,
Terminated.
it's already in admission.
What's the,
List after 2 weeks, 3 weeks.
because similar matters are there, same matters, Lordship, they may be listed together.
Okay,
Another one was listed in the court for today itself. So those cases.
next time you mention it.
Lordship.
If it's listed in both the courts,
Yes,
it will be difficult. It is listed today,
yes.
so it's difficult. You could have mentioned there. Have you mentioned there?
Lordship, the petitioner, counsel had prayed for hiding lot the bridge and
Okay.
in that way.
You mentioned on next day,
Yes,
list after 3 weeks. You have been already terminated.
Yes.
Item number 18.
Yes.
Lordship, may I seek to show a commission of 1 week?
For what?
Have to file a appealable reply?
Reply.
Yes.
On the prayer of. No, Mr. So and so. Huh? Learned counsel for the petitioner. Press for and is granted further 2 weeks time to file affidavit in reply to the affidavit in the filed by the state respondents. Mr. Anderson and additional advocate is present. This accordingly after 3 weeks. 3 weeks.
Item number 33.
Please, your lordship. Your lordship, in the same, for the same accused, your lordship, this court has already rejected the bail. And here in this case also, your lordship, they have taken the ground of arrest only, the new ground. So that has already been adjudicated by this honorable court in BA number 76 and BA number 2 of 2025. Yes.
Same, out of same.
Same FIR, co-accused, my lord. And sufficient material is there, your lordship.
So what is to be done? With the counsel for the,
This for the victim, my lord.
what is to be done? Let us give One more,
One more chance, yes, sir.
Friday,
Okay, your lordship.
Friday,
Okay, your lordship.
if you can, you inform
Okay, your lordship.
the council, huh? The note appears for the applicant on call. Mr. T at the London Edison PPM. MS H. Jerem, London Legal Aid Council at present. So in the interest of justice, let this matter be listed again on
Friday,
Friday is 24.
24.
You just, if you can, you inform.
Yes, I will inform.
Otherwise you'll dispose it.
Okay, deeply obliged.
Item number 34.
Yes.
On last occasion also, your lordship, the petitioner side did not turn up, your lordship, on 24/9/2025.
Granted interim bail.
Yes, your lordship.
Then
Earlier, your lordship, yes, in security bail, interim has been granted, your lordship. Kindly, see the last order, 24/9/2025, madam.
we have the updated case diary.
Lordship, the case diary is not updated as such, but then, the relevant documents are, it does say that.
What is there? Anything?
There's nothing as such because, otherwise the case is that while,
We'll list it next week. You obtain the updated case diary. And if possible, last time occasion also non-appears for the petition. If you can, you just inform,
yes,
not, will not record it, which you can just inform the lawyer,
yes,
right?
yes, your lordship.
Non-appears for the petitioners on call, listed. On the last occasion, the matter, when the matter was listed also, when the matter listed, the petition, no, represented the petition, applicant. Mr. MSTG learning additional people to produce updated case there on the next stage. Just of this, that this matter be listed after a week.
Sorry. Deeply.
Item number 35.
Yes. Anything?
May I read the case diary?
Hmm?
34.
Yes.
We have received a case diary, lordship, where it is stated,
And who is for the petitioner?
petitioner lordship, some Hangpa Sumian.
You keep it yourself. Take it after next week.
Yes.
After a week, you take it out in the next week.
Yes.
Non-appears to the petitioner on call. MS El Hagelan, additional PP is present with the case diary. Mr.
Matter number 36,
Like,
Same,
yes, same lawsuit, out of
out
same.
of same FIR,
Yes, lawsuit.
35 and 36, separate orders, same. Next week or Friday?
Next week, lawsuit, because I don't know who is the petitioner counsel is not, the applicant counsel is not there, lawsuit.
Hang Pua
Yes,
Sumyan. Just inform.
yes, lawsuit.
matter number 7,
Yes.
72 to BNSS lawsuit. Regarding 72 to BNSS.
It's for recalling of the warrant.
That's what I'm saying.
But here I am challenging the order by which the warrant has been issued. I am saying that it is totally non-application of mine method.
So you go back to the court which has issued the warrant for recalling or cancellation.
But the order that would remain.
What is the purpose of your this thing?
Hello?
What is the purpose of issuance of warrant?
Well, the
For
allegation is
appearance only.
appearance only before.
So they're saying that you are not cooperating. You go back, you appear and you file an application. I think this court, as a lawyer also, I think we used to file an recall application for recall or cancellation by appearing.
But in the facts of this case, we will file in the application, which has been submitted before the court.
No, the reason means that the IO has said that you are not cooperating. So since you are saying that you are cooperating,
Some material the IO has to show that, my lord, some
It's all right.
summons issued
no,
by.
that's what I'm
him,
saying.
some
It is not
controversy,
only
my lord,
for, it is not only for, it's not for conviction or sentence.
Gotcha. Gotcha.
Or punishment.
Gotcha.
It is for appearance only. To appear before the police or to appear brought before the court. So you approach the court, which definitely they'll consider.
That case, lordship will,
Because you will not
give me
be,
liberty and, my lord, this warrant that has been issued, that may be stayed.
no, we'll not say that. We'll say, we'll give you a liberty to approach in terms of the, as per the provisions of the law. Because if you file an application, definitely that will not be executed.
My lord,
before
it
it
says
is
warrant has already been issued, the person
No,
has
that-
come to my residence, but the police, my lord, while I was away.
That's
So
right.
then
You,
only I came to know
that's
about
right.
this
You
order.
you go there. It has not been executed as yet.
So there was that, my lord, that interim protection at least, lordship.
No, it's not. It's not. We'll just grant you to approach the court as per the provisions.
But no protection will be given to him.
No, you'll not be until it is executed. It's only execution on.
Well, they have gone to my residence. I have given the date.
You go there. You will be there.
I am staying in Guwahati.
You-
But I have also submitted my
You
document.
file the affidavit. You filed an application for recalling and appear. That I'm ready to appear. I have not been even any summons or any notice under the law. So this may be recall. I'm ready to appear. I'm ready to cooperate. That's all. And definitely they'll consider.
Yeah.
Why I'm saying as a that side, I mean as a lawyer, I had the experience.
That is the, my lord, here the peculiarity of this.
Only that,
circumstance, my lord, the person, my lord, he is at Guwahati. He has appeared before the court. Now, my lord, under the medical treatment, he cannot move. My lord, while the, my lord, police has gone there,
Oh,
he has gone.
That will be difficult.
And my lord, so far as, my
That
lord,
will be difficult, sir.
my lord, what I am saying, my lord, the issuance of the thing, my lord, the Supreme Court itself has, my lord, on various decisions has said, my lord, it touches the, my lord, personal liberty of the person concerned.
Okay, but then when there is a provision for recalling and when you can approach the court which has issued the warrant.
But I am moving this court under 528, my lord, what is akin to the 482. Or at least lordship will give me some protection, at least some days of some protection lordship will give so that, my lord, I can approach the court. Appearances, my lord, because I am not being able to move out of the Guwahati. That is there. My lord, at least the council will make an application sometime maybe.
That will be difficult. It has not been executed as yet.
He should be appear before the lordship CGM for recording lordship.
All of you, 4 of you, including the boss, PP, tell us, what should be a way out?
Please approach me.
Can you just issue a non-bailable warrant of arrest on just asking by the IO?
Certain questions are there,
Yes.
but someone has to be issued.
Therefore, just because what is saying that no someone, nothing, you have just said that without issuing all that, on the basis of the IO that he is not cooperating, so you just issued a warrant.
At this stage, we don't know anything also. We have to call for the instruction whether they have issued a summon or not.
So in that case, we'll issue notice and stay the execution of the
Lordship,
warrant.
execution should not be state lordship because the procedural lordship, it is a provision there to approach before the same court for the recalling lordship. The provision is there, lordship, he should have
Where
appeared.
the
before the-
provision says that it should be approached before same court.
Plus 70,
Read it.
lordship,
He has the power to cancel and recall. That's all.
yes, or the same court lordship.
Huh?
Same court lordship, it should be recalled lordship. It is.
Yes.
Far as your the inherent power is concerned, madam, it shouldn't be invoking mechanical. There should be an exceptional circumstance. Otherwise, your
The exceptional circumstances is that you have not, the court has, while issuing the warrant of arrest, has not applied the law and applied his mind.
What if your lordship?
Simply because on the basis of the, they are asking of the, IO, that he's not cooperating, you have not issued any summon.
May not be 40 parts there. Maybe only 3-4 occasions your lordship, the IO has imported, he has not cooperating with the investigation. And secondly, my lord, it is not to aid the police, my lord, the court will call the person to appear for.
That's the problem.
And then-
What is the reason of non-malevolent warrant? Reason is that he on the basis on the asking on the saying of the on the basis of the ground the statement of the IO that he's not cooperating, therefore warrant issued. Can it be done?
And one more issue is there, man.
Yes.
He was earlier granted bail on, it is also one of the expected, just we take into consideration. And if your lordship.
It was granted, it has been cancelled. The cancellation is also very, very strange.
Your lordship, if he is not.
Look at the where is page cancellation of the bail.
My lord, because the procedure is that, my lord,
That's because you have not deposited the amount to be deposited on the other day you have deposited. I mean, the accused has deposited, therefore it has been cancelled.
But that is also, that finding is also wrong. My lord, I submitted an.
Where is that order of cancellation?
41.
41, my lord.
I had.
Page
I had-
41.
While I appeared before them, I have submitted certain documents, including a my lord, receipt showing payment of 50,000 to the informant. That receipt has been taken into account as if I have deposited in the court. While I have deposited my lord, in the court on 12/1 as per the direction of the IO, my lord.
Here of name, my lord. Complied with the bail order, my lord. Bond. May I read your lord, the order?
It is apparent that the investigating officer has not investigated the case properly and committed the dereliction of duty and prejudiced the complainant's case. It is evident the petitioner has deposed and should be served the investigation of the case, who is accountable for me. Good person in investigation.
Order has not been challenged.
Will issue notice, you think about it, it will give you a liberty to approach in the meantime.
That is, my lord, the-
This will be difficult to stay the warrant. Execution, it will be difficult.
that is the my lord, reason, my lord, the person staying at my lord Guwahati, my lord, going to the GO.
That is the more, that is the another actual difficulty. You are in the Guwahati cases here. That once you are granted, once all these things and orders are passed in your favor, you'll never come back. You will never join the investigation.
But that is, my lord, that's what I'm saying, my lord, that 50,000, what they is saying, my lord, it is the receipt.
See, when the bail was also granted, you are supposed to appear and
I did appear, I did appear.
no, it doesn't say so.
No, my lord, can I say even in the application itself, you will also
Not the
find.
application in the order, cancellation order,
My lord, that,
cancellation order.
my lord, that is the whole thing,
It
my lord,
might
the
be-
application, your lordship,
According
can
to
you
the
see-
court,
lordship, you can you see page 44.
there is a, what do you call? There's an observation of the court that you have influenced the investigating agency.
My lord, that is,
Appears to have this, and you have accepted the bail amount, I think, via the bank transaction.
my lord, that was
And
done
it was
on,
the transaction done on the bank account of district and session.
lordship, my lord.
State Bank of Shows the 50 was declared in the court's account. So the net banking was shown.
Madam, this thing, my lord, I was granted interim bail on 12/6/2024. There was no direction for me to appear. But then I appeared, my statements recorded. And also I have submitted my lord, certain documents. Bail bond has been my lord, submitted, duly signed by me. Now, from the my lord, orders, it reveals my lord, the officer, investigating officer has not signed the bail bond. So that fault has been attributed to me. So far as 50,000 deposit is concerned, my lord, when I, my lord, execute a bail bond, there is no requirement of depositing any amount. It is only the bail bond suffice. Now, this 50,000 was a receipt by which I have paid 50.
So you are not challenging this order? Cancellation you are not challenging?
I'm not telling you, because I'll have to, my lord, apply a fresh bail. My lord. There's no ground for, my lord, challenging the, my lord, cancellation bill. Because it was an interim order that has been, my lord, vacated. I file a fresh. Till then, my lord, this execution of the, my lord, warrant, your lordship, filed on 6/10, the IO has said.
I think, sir, you have to file application for cancellation or recall.
My lord, first of all, my lord, this code,
Will issue notice, will give you a liberty.
my lord, this code is not denuded with the power of, my lord,
It's not
in the order, my lord.
We'll have to,
But nonetheless, if your lordship,
we'll have to,
at least,
it also says that we'll have to spare, exercise sparing. Not all in the sundry cases.
but
But Mr.
on
PJ
face of
Sekar
it, lordship has seen, my lord,
will give you a grant, liberty.
the
Pendency will issue notice.
the execution, my lord, the execution
We'll
certificate.
see whether they have, before this, whether the IO has issued any notice or whatever summons. We'll see to that. In the meantime, we'll give you a liberty.
Some protection had it been given, my lord.
Anyway, it's that's right. Heard Mr. PJ Sekar, London Senior Counsel, assisted by Mr. K. Lowell, London Counsel for the petitioner. Next para. Challenge made in this petition is today. Order dated 10/06/2025. Passed by the Chief Judicial Magistrate, Lower Subansiri District 0. Whereby a non-bailable warrant of arrest against the petitioner has been issued in connection with the
0 PS case number 17 of 2020.
0 PS case of 17 of 2023. Issue notice returnable by 2 weeks. 2 weeks, make it 2 weeks. MS El Hage, Learned Edition PP. Accused for the state response. For the state. Having next paragraph, consider the provisions of section 72 within bracket 2, bracket close of BNSS 2023. And also considering that the bail, entry bail granted to the petitioner having been where it is?
That is 41.
Ah,
That's not for my, my lord, default, but for the, my lord, faulty investigation of the, my lord, I.
but courts is of the view that you have influenced the investigation officer, investigating agency.
My lord, in see, my lord, the interim order granted, bail granted, there was no direction for me to appear before them. There was no other conditions. Only thing is that in the event of arrest, I shall be released on bail on execution of a bond of 50,000. To cooperate with the investigation, I myself has gone.
Order dated
Lordship, kindly before that, my lord, page 37, only one page, my lord.
Where is the interim order, bail order?
Interim order 12/6, my lord.
12/6/2024. What is it? Yes,
Sorry, my lord.
last.
6/6/11/23, my lord, page 35. 6/11.
Cancelled.
Page 35 is the interim.
Where is the cancellation?
Cancellation is on page 41.
14, huh?
41.
Where it is? Relevant para, cancelling is.
The fourth paragraph from top, my lord. The above observation clearly shows that petitioner accused has willfully avoided participating in the investigation, rather resorted to unfair tactics and influenced the investigating agency. In the result, the interim bail granted to applicant others is cancelled.
Chumbel. Yes. On 24/10/2024 by the Sessions Court. The petitioner may approach the jurisdictional court for recalling of the cancellation of the NDA and non-bailable of non-bailable warrant of arrest. Impugn and non-bailable of the arrest.
Only one, but that page 37. The GD entry, my lord, that has been recorded, my appearance along with
We'll see where we should notice.
Apply those.
Well, liberty that has been granted to me to approach. That liberty has been given. Can it be under 4 weeks? Because within 2 weeks, it will not be possible for him.
3 weeks. 3 weeks. Make it 3 weeks.
Apply.
Item number 37.
May I appear, Lordship?
Yes.
My lord, here the criminal petition, revision petition was already been admitted.
Hmm.
The record was called for.
Hmm.
And this today is for my lord. I have filed an IA for suspension of sentence. Here the petitioner was convicted in section 26 IPC for period of 2 years. Now he is in jail. Till pendency of the revision petition, your lordship, the petitioner may be
4 years.
no 2 years.
2 years.
2 years.
When it was conviction, sentence.
Sentence is for it was convicted on 1/7/2025. Till then he is in the jail. It was convicted by the judicial magistrate Namsai. Then against that order, we have filed an appeal. Appeal was dismissed. What is there?
No, you're not.
Report was for more. I have,
Call for the records. We'll see.
yeah.
We'll see the
report was
records and
already called
consider.
for. Report was already called for.
This is yet to receive.
Yet to read.
We'll see the records. Okay.
That's part of it. And my
What is the offense?
326.
326. Grievous.
EBS hard.
We'll see.
Allegation is there.
Heard Mr.
But that section, to my understanding, is not applicable.
Okay.
It may be at best 320.
We'll consider. We'll consider, see the requirements. Heard Mr. S.K. Devi, learned counsel for the petition, applicant, public appellant, and also Mr. M.S. T.G. learned additional people for the state. Office note indicates that trial court record is yet to be send reminder. Arrested to send reminder. This the matter. As agreed to well and counsel for this matter after 2 weeks. 2 weeks. 2 weeks.
After receipt of the report, Your Lordship.
I think it's better.
That's
This matter on receipt of trial court report.
Matter number 38,
Yeah, please, Lordship. Your Lordship, as I have gone through the record, Your Lordship,
Yes.
one respondent number, the SR report is written, AT card is written up in
Respond number 1.
respondent number 1.
But not respond number 2.
2. Not
Heard Mr.
okay.
K. Gara, learned counsel for the petition.
Now, I may be allowed to take press statement
Okay.
to the respondent of
Office note, next paragraph, office note indicates that any card in respect of respondent number 1 has been received. Like service notice upon respondent number 2 is complete. And as Mr. Gara and counsel correspondence is granted a week's time to take process steps for respondent. Service of notice upon respondent number 2.
In the meantime, interim order may be continued.
Interim order was against continue. List after 4 weeks.
matter number 41,
May I have Lordship, please?
Heard Mr. So-and-so, and counsel for the question. Await service report in respect of respondent number 2. List after 3 weeks.
May I have Lordship? Lordship, this is the criminal petition, Your Lordship.
Yes.
This application under section 528 of BSN.
Sir, we are waiting for the service report in respect of respondent number 2.
Your Lordship,
wait
it's
for
been
some
2 months ago, Your Lordship.
Then you take a process steps. You take process steps. Want to take or you want to wait for some time?
Press step, Your Lordship.
Okay. Then you say office note so-and-so, indicate so-and-so. ID card is yet to be received in respect. And no ID card has been received in respect of nurse number 2. Mr. So-and-so learned counsel for the petitioner. Press for is granted a week's time to take his press step. List the matter after 4 weeks.
4 weeks, Your Lordship. Your Lordship, actually this petitioner may be arrested, Your Lordship. Maybe this trial may be started at CGM court, Sanglang, Your Lordship. May be listed very shortly, Your Lordship. The 2.
No, since you are taking steps within 1 week, then make it 3 weeks. To ensure that he received the notice. The respondent number 2 received the notice.
Your Lordship, hopefully he has received the notice, Your Lordship. Is intentionally is thing lies. I don't know, sir.
We don't know. Okay.
Yes.
Thank you.
All right.
all right. Matter number 44,
What about 42? 42? 42. Huh?
This is a criminal petition
Hmm.
knowingly filed by the victim accused and their complainant.
Hmm.
The charges has been framed under section 307
307.
IPC.
Okay. So,
Also, the lecture one, page number 16 is the copy of the charge sheet.
16.
Yes.
Yes.
The relief
Your-
portion,
Your nephew or niece?
actually it is in this.
Then why you have said in
That,
entire
Only,
petition you have said nephew?
yes.
You have changed the gender of your relative. Huh?
Petitioner number one is the victim. What
Hmm.
happened is on 11/9/2017 at around 12 a.m.
She's MS, she's nephew or niece?
His niece.
Yeah. Yes.
On 11/9/2017 at
Hmm.
around 11 or 12 a.m. this accused person, petitioner number 3, repeatedly called the petitioner number 1. And to confront the accused person, petitioner number 3, is petitioner number 1, the victim, went to the house of the accused person.
Hmm.
And there some scuffle had happened. And it is alleged that the accused person has used dao and hit the petitioner number 1 stomach. That is the allegation. Then the fire was lodged under section 307, 354D.
Hmm.
But the charges was framed only under section 307 IPC. Now it is at the stage of now this has been state. The trial is yet to begin.
Yes.
After that, they have compromised the settle the matter mutually.
You inflicted an injury, then you compromise the issue. I mean the matter.
It's just yes. The family members of both the victim and the accused, they have settled the matter on 6 June 2023. Thereafter, the settlement agreement was also executed. Deed of agreement 26 July 2023. On that basis, this agreement petition is filed. I'm relying on the Lakshmi Narayan. Yes, sir.
Yes. It is simple injury.
Yes, injuries.
They are relatives. Niece and the uncle and the niece. Let them audio list in future. Had Mr.
B. Padu.
B. Padum done counsel for the petitioners. And Mr. B. Loy Lanu for the state. This is an application. Number section 482. CRPC 1972. Within the there corresponding to 580, what?
528.
583,
528.
528. BMS 22, bracket close. Praying for postment of Passing at sessions case number 32, 2022, under section 307. Appreciate. On the basis of settlement between the
Item number 42,
My lord, this is an IA for condonation of delay, my lord.
what?
With respect to CRP, we have filed challenging the impugn order dated 16/07/2015, passed in civil case number 04 of 2000.
Hmm.
My lord, this dispute was between two villages, my lord. Survi
How many
and
days?
my lord,
Delay of how many days?
10 years, 9 months, and
10 months.
10 years, my lord, 10 years.
Okay.
And my lord, we have very good reasons for it, my lord. We weren't aware, my lord. I am a resident of Bombay village, my lord. Bombay village, my lord.
Explain day by day.
My lord,
Every day is delay.
my lord, I came to know about it only in the year 20.
Will not ask for every hour, every minute. At least, not even a day, every month's delay.
My lord, I only came to know about it because I am a resident of Bombay village and the
Not
dispute.
Mr. M. Pertinent counsel for the petitioner and the applicant. Next paragraph. This is an application under section 5 of Indian Limitation Act 1964, referring to a combination below 10 years, 2 months, and 9 days. In filing the connected civil revision petition. Against the order dated 16/7/2015, passed by the Tree Commission from District Magistrate Tawang. Issue notice returnable by 4 weeks. Who is appearing for the state? Deputy Commissioner. Take steps, sir. For all. Listeners, applicant to land council applicant take steps to serve and not the respondents. All the response. Let's take your seat.
item number 45,
We have only 2 matters. We'll resume at 2. Right.
Yes.
You take time.
No. From my side, my life wouldn't take much time.
How long you will take?
Much time, my lord.
If you are going to take more time, we'll start now
No, it will not take much.
and we'll resume at 2.
Yes.
item number 46,
Well, this application under 42. Challenging the final form report, that is the charge sheet dated 25/2/2021. And the order dated 12th of March 2024. Wherein my lord, charges against the petitioner was framed under 376, 417, 323, 427, and 506 of the IPC. I will just take your lordships to only 3 documents, in fact, maybe even 2. The FIR is at page 16. The FIR, my lord, would reveal that there was a conscious decision to enter into a physical relationship by the prosecutrix on the promise to marriage. That, my lord, the Honorable Supreme Court has made the distinction now. If there was a conscious decision, there is no question of 376.
If I page
15,
15.
16, 16.
Okay.
With humble submission, I'd like to inform before your good authority for necessary action against the aforesaid accused person that on 17th of December 2017, for the first time I met the accused person at Panyo River Festival at Jiyajali, and the accused person used to frequently call me and on many occasions proposed to marry me, informing that he is a widower and single, and I have to take care of his 4 children born out of his late wife. The accused person's constant proposal for marrying me with sweet talk made me believe that he's a good person, and finally I agreed his proposal. There's a decision made by her. The accused person asked me to stay with the A sector and forced me to have sexual relations with him on promise that he will surely marry me in a formal way as per customary law. With hope that the accused person will keep his promise, to marry me, I could not resist the accused to have such and such with me on his promise at the behest such and such. So in my humble understanding, there is a conscious decision made by her on the promise to marriage. I'm going by what they are in the FIR. Now, similar is the tone in the 161 statement. There is at page 26. Similar, my lord. What has happened in the meantime?
What is he?
There was no stay. At page 26.
Hmm.
Similar. It's almost the same to the FIR. That on the promise to marriage, he entered into a physical relationship with the accused person. Now, in the meantime, since there was no stay, the trial went on. And the prosecutors has now been examined. My lord, the certified copy, my lord, is in the records. Since it's a certified judicial, where your lordship can take cognizance of it. Here, my lord, forget about even entering into a physical relationship on the promise to marriage. FIR, my lord, is not a piece of evidence. 161 statement cannot be taken into account. In the deposition, there is not even a whisper that she had, in fact, consensual physical relationship with the accused also. Even not, that is not there. Married. Here, there is nothing here. I am from Joram village, presently under K. Panor district. I am a government servant. I was in with relationship with the accused person, namely such and such, on promise of marriage. I met him on 17 during Panyo River Festival. I went to the festival with my teacher colleagues. I met him in the festival during evening. I don't remember how he has received my phone number, though. I have not shared with him. Next day, he gave me a message from unknown number mobile asking me to come to River Festival. I did not went to meet the accused, but went there to meet my other relatives. There was gradually interaction with such and such. Therefore, after he proposed me for marriage, but I have refused. I told that I am not willing to have relationship without following rituals for marriage. I was told that wife of such and such died and he has 4 minor children. I was asked to stay with him to look after his minor children. I asked him to talk to my family members. Then they came to my home and have talked with my family members. This is the deposition. I stayed with him. That is after he talked to his family members. I stayed with him on his promise that he will perform the rituals of marriage as per customary way and talk to my family members. It's been months. Promised to do the same, but he did not do any such things. As and when I asked him for performing his promise, arguments crops up and he used to physically assault me and used to tell me he's not in a position to do the same. Initially, I told him I was not ready to stay with him for about 2 years and went to stay with him only on promise that he will discuss with my family members and perform rituals. Whenever I remind him to talk with my family, he starts physically abuse me. He even kicked and punched me in front of my friends. After about 4 to 5 months, he told me he has no money for admission of his children and asked me to take loan for him. Accordingly, I have taken 3 lakhs from one person, 2 lakhs from one person, 60,000. I have also worked on a NIPCO Jajali and earned some profit of 4 lakhs, but all the said amount are used by Tabat such and such. Whenever said lenders ask for money and ask such and such for repayment, he used to physically assault me. He has punched and kicked me in front of my friends. He has pushed me away from home after throwing away my goods and materials. Once he even dragged me out of his home and my materials at a sector near Rajbhavan. I even taken rent at Itanagar. He did not allow me to stay in the rent house and asked me to stay in the residence to look after his children. His youngest daughter was 3 years of age and I looked after his children as my own. But one day, all of a sudden, he went away from the residence with 4 children and materials to live at the residence of his brother, namely such and such. When I called him over phone and inquired about the matter, then he told me that he does not want me. I told that he promised to marry and he made me cohabit with him since long and he died stating he does not want me. I stayed at his residence for about 2 weeks and consistently asked him to come back, but he denied. I even asked my helper from whom took with him to ask him to come, but I was told that such and such was not allowed her to come. He has not come to me, that even has not allowed the children and helper to come to me. After about 2 months, he filed an FIR against me at Women PS Itanagar. It is falsely alleged against me that I have tried to grab his residence. It is also alleged that I am trying to kill him with revolver. It is alleged that such and such. Thereafter, he asked me for solving the disputes through local cover. I told him that I am a guard. He does not marry me, then he may also not humiliate in presence of public. I asked him for mutual settlement. However, he threatened me as to what I can do to him. I have informed the matter to my father over telephone, asked him to solve the same. My father had a talk with Tabasi and such and told them there will be cover at Joram General Ground. My father requested not to do such thing, but amicably solve the dispute. Accordingly, our family was called to the residence of Tabatechi at Pitapur. Where we went there, we were not allowed to enter the residence and has already called GBs as his supporters and had discussion about the matter of residence, where he put a tent on the open public. He has thrown rupees 10 lakhs at my father, which he took from my father on earlier occasion. I was told in public that I am having a psychological disorder and he will not marry me, such and such and such. But the accused told me I did not have any issue, but I am not mentally sound. I was told that I asked for such and such, and I asked for such and such, such and such. There could not be any local settlement due to denial of Tabatechi. When I went back to my house, found my residence locked. I had taken assistance of police to take my material, but he has alleged no complete theft. He also damaged my vehicle, including tires and rear view mirror. Accordingly, on such and such, FIR was closed. These are the exhibits. In the close examination, he admits that we were in a relationship for about 1.5 years. We stayed together in the same residence. In the light of this deposition, my lord, how does 376 stand? My lord, in fact, see, this is a relationship that went bad. And when the accused person, in fact, wanted to have an amicable settlement by Kaba, they did not want it. They don't want it to do it in public. These are things I don't want to go into. But the fact remains, in this deposition, there is not even a whisper regarding consensual sex also. That's it, man. There's nothing.
It's a matter of pride. Why did you go to trial? Complete the trial.
Trial is going on, my lord. Why should I be, my lord, made to suffer like this, my lord? The deposition has come now. Your lordship can always take cognizance, my lord, in judicial court document.
You were in relationship for 1.5 years.
Yes.
Stayed together in same residence.
Yes. Exactly. That is why, my lord, the petition should be allowed. So, lordship, if I may just place a judgment. Once you stay and have a relationship, where is the question of 376?
Charging only 376.
No, 376, and there are this ancillary charge. 417 punishment for cheating. Once 376 goes, 417 will go. Mischief causing damage, the amount of 15 rupees. There is no evidence of that also. If your lordship feels that this two goes on, this may go on. But 376 and 417, how does it stand? Page 616. Section 90 has been defined. 616, madam. Section 90 has been defined. Then paragraph 12 onwards. Lordship may kindly have paragraph 19 that will suffice, madam. 18 and 9. At page 620. To summarize the legal position 18, that emerges from the above cases, the consent of a woman with respect to section 375 must involve an active and reasoned deliberation towards the proposed act to establish whether the consent was vitiated by misconception of fact arising of the promise to two promises must be established. The promise of marriage must have been a false promise given in bad faith when with no intention of being adhered at the time it was given. The false promise itself must be immediate relevance or bear a direct nexus to the woman's decision to engage in the sexual act. The allegations in the FIR indicate that in such and such, the FIR initially refused to engage in sexual relationship. Here also he says he refused the relationship itself with the accused. But on the promise of marriage, he established sexual relationships. However, the FIR includes a reference to several allegations that are relevant for the present purpose. They are as follows. The complainant and the appellant knew each other since such and such. The complainant and the appellant made regularly travel great distances to meet each other. The appellant expresses reservation on marrying such and such. Paragraph 21 matter. The allegations in the FIR do not, in the face of it, indicate that the promises by the appellant was false or that the complainant engaged in sexual on the basis of marriage. There is no allegation in the FIR that when the appellant promised it was done in bad faith or in the intention to deceive her. The appellant's failure in 2016 to fulfill his promise made in 2008 cannot be construed to mean promise itself was false. In fact, my lord, after the deposition, even these things are not relevant anymore. In the deposition, there is not even a whisper regarding consensual relationship also, physical relationship. Other place, my lord, if you also may have paragraph 19, 18, but place 199. These are, my lord, in fact, where there's a false promise to marriage. In fact, from the deposition now, there is no allegation of even having any sexual encounter itself. That is not there anymore. In Uday versus State of Karnataka, this court was considering a case where the prosecutor is aged about 19 years had given consent to sexual intercourse with the accused with whom she was deeply in love on the promise that he would marry her on a later date. The prosecutors continued to meet the accused and often had sexual and became pregnant. Here, my lord, she in fact started staying with him. The complaint was lodged on the failure of the accused to marry her. It was held that consent cannot be said to be given under a misconception of fact. It was held thus. It therefore appears that the consensus of judicial opinion is in favor of the view consent given by the prosecutor to sexual intercourse with the person with whom she is deeply in love on a promise that he would marry her on a later date cannot be said to be given under a misconception of fact. A false promise of marriage is not a fact within the meaning of the court. We are inclined to agree with this view, but we must add that there is no straightforward formula for determining such success. Now, in fact, after this deposition, my lord, this will have to be taken into account, my lord, at trial court. There is not even a whisper of, my lord, having any physical relationship. Leave apart, my lord, by misconception of on the false promise of marriage. There's no question of, my lord, allowing the trial to go on under 376.
What about the other sections?
Other sections, yeah, this will have to go 417. Even others, but I'm not calling for lordship to determine it on the basis of this. That is why I'm not pressing on the other charge. But 417 and 376 will have to go. Others, but we will find it out there. Because these other charges also, there are vague allegations here. There is no material.
You are challenging the charges,
Yes, we are challenging the charges.
framing of charges,
Yes.
and it's 376 and 417.
But we are challenging all. If your lordship deems that 427 and 506 can go on, then it may go on, my lord. Otherwise, for that also I am submitting, my lord, there is nothing. There is no. In fact, these judgments are, my lord, irrelevant now because of the deposition made by the prosecuting reporter trial.
Yes, sir. Well, yes, senior counsel is heavily relying on this deposition of the victim, my lord. First, my lord, I have submitted, my lord. This, my lord, is a deposition before the trial court, my lord. The statutory right, my lord, to consider, my lord, this deposition is in, to the statutory authority, my lord, to deal and consider this deposition is, my lord, trial court, my lord. After that only, my lord, in appeal, my lord, yes, this court, my lord, can consider that, my lord. In the revision, I humbly believe, my lord, this cannot be a subject matter of deposition on the deposition of the deposition of the victim, my lord. The law forward, my lord, it's need to be first considered by the trial court, my lord. Thereafter only, my lord, after passing any order, my lord, this court can consider in the appeal, my lord, not in the revision, my lord. So at this stage, my lord, the argument, my lord, and the hearing, my lord, will limit only to the any perversity, my lord, in the charge sheet, my lord, and in the charge order, my lord. Now, my lord, it heard the senior counsel, my lord. He has not pointed out any perversity, my lord, in the charge order, my lord. That apart, my lord, the only issue he is raising, my lord, false promise, my lord, would not be raised, my lord. Now, that issue, my lord, has been fairly and fairly deal by the trial court, my lord, in his charge order, my lord. Yes, my lord, every, my lord, false promise, my lord, section under false promise cannot be raised, my lord. But it not that, my lord, it will always not rape, my lord. It depends upon the fact and circumstances, my lord. Now, that fact, my lord, can whether from the fact, my lord, necessary fact, there was a rape or not rape, my lord, that can be considered only after proper evidence, my lord. Now, that is going on to the trial court, my lord. Now, without any fake, my lord, any evidence, my lord, this honorable court, my lord, in the revisional jurisdiction, my lord, until
It's not revision, it's 482 petition.
yes, my lord, 482, my lord. 482 corresponding revisional only, my lord. This cannot be appealed, my lord. Otherwise, my lord, if under 482, my lord, court cannot be appellate jurisdiction, my lord. Surely, my lord, when he is challenging a charge order, my lord, that will be concurrent corresponding to the revisional jurisdiction only, my lord. Cannot be appellate jurisdiction, my lord. Therefore, my lord, my humble understanding, my lord.
Whole foundation is on the false promise
Yes, my lord,
to marry.
my lord. Now, whether the fake relate to enter into sex, my false promise, my lord, will come under the rape or not, my lord, that would to be determined through the proper evidence, my lord. Evidence, my lord. Now, that is going on, my lord. Until in absence of any record, my lord. Now, I humbly, my lord, the evidence, the deposition, my lord, of that post-trick, my lord, cannot be looked into by this court while exercising 482 jurisdiction, my lord. That is past absolute authority to consider that is by the trial court, my lord. Thereafter, only in the appeal, my lord, this court can look into those report, my lord. It is that cannot be, my lord. There, yeah, but this consent, my lord, what that judgment relied by the senior court, it says, judgment say, my lord, it the consent, my lord. Consent, my lord, of the consent can be always vitiated by misrepresentation of the fake, my lord. Now, whether there was misrepresentation of fake or not, my lord, I humbly believe, my lord, that would be, my lord, matter of the fake, my lord, and that would be determined only by evidence, my lord. So I humbly believe this, there is no merit, my lord, in this case. In similar situation, my lord, in coordinate bench, my lord, he has discussed the judgment relied by the other side also, my lord, in this case, my lord. At this stage, my lord, until and unless some perversities, my lord, we point out point out in the search order, my lord, that para 14 and 15 would be relevant in this case, my lord. Similar submission, my lord, same argument, my lord. Now, this coordinate bench, my lord, in para sorry, my lord, the 15, my lord. 15, my lord, just next page, my lord. Para 15, my lord. I'm escaping all other, start at next page, my lord, the petition under, my lord. Petition under 482, and it is a duty of the prosecution to prove the charge by the producing necessary evidence during a trial. And to frame the charge, the requirement is to have prima facie case. The honorable court in a case of state or assassin. Oh, sorry, my lord, this is not, my lord. The para 14, sorry, 14, my lord, 14. 14 is 14, my lord. The 14, my lord. I'm skipping the other parts, para, my lord. Start from 9, the sub clause 9, my lord, para 14, my lord. Having gone through this is the part of the judgment, my lord, of in honorable decision of the Honorable Apex Court, my lord, in Central Bureau of Investigation versus Arians, my lord, 2023 SCC online SC 7370. Para 9, my lord, having gone through the impugned common judgment and order passed by the High Court, passing the criminal proceeding and discussing the case, we are of the opinion that the High Court has exceeded in its jurisdiction in questioning the criminal proceeding in exercising the limited power under 482 CRPC and in exercise of the power under Article 226 Constitution of India. From the impugned common judgment and order passed by the High Court, it appeared that High Court had dealt with the proceeding before it as if the High Court was conducting a mini trial. I am taking position, my lord. Now, if his submission, my lord, is to be accepted, my lord, he is praying for to consider the deposition, my lord, of the who is a subject matter of trial, my lord, and yet trial court is yet to consider, my lord, that particular deposition, my lord. He is praying for consideration of that deposition by this honorable court, my lord. That I believe, my lord, will be amount to mini trial, my lord. As part of cardinal principle of law, at the stage of discharge and quashing of the criminal proceeding while exercising power under 482, the court is not required to conduct a mini trial. The High Court in the common impugned judgment and order has observed that the charges against accused are not true. This is not the stage where the prosecution investigation are required to prove the charge. The charges are required to be proved during a trial on the basis of the evidence lead by the prosecution investigation agency. Therefore, the High Court was material in going to detail in the allegation and the material collected during the course of investigation against the accused at this stage. At the stage of discharge or while exercising the power under 482 CRPC, the court has a limited jurisdiction and is required to consider whether any sufficient material is available to proceed further against the accused for which the accused is required to be trial or not. 11, my lord. On another reason point of the High Court in that initiation of the criminal proceeding is malicious. It is required to be now thereafter, my lord, at para 15, my lord, by this para 15, my lord. After hearing the submission made by Land Council for the site, pursue all the relevant record and the initial file along with the petition. It seemed that there is no dispute that the both the petitioner and the respondent had sexual relations for considerable period. And it is seen that even after the transfer from the Itanagar, they have also maintained relationship between them. The respondent number 2 even stay along with the petitioner for more than 3.5 months in the same house. Similar to, my lord, this particular case. It is also submitted by the Land Council of the petitioner that in the statement made by the respondent number 2 under section 164 CRPC, as from the statement made in the FIR, he was aware of the fact that the marriage between the respondent number 1 and the petitioner number would not be possible at they belong to different community, my lord. In my case, that is not there, my lord. In this here, my lord, the petitioner, my lord, was widower, my lord, and having 4 child, my lord. It is the proposal was made, my lord. And we belong from both the same community, my lord. The marriage can be possible, my lord. Now, this is the grammar. But it also cannot be denied that though the initially placed the heavy in the sexual relation with the petitioner, but subsequently she gave her consent at the promised following the petition that he will marry her and will also convince his parent equally he obtained her consent and hence. It cannot be said that there is no in misconception fact in the ethics section 376. But it's seen that after prayer the stand of witness and considering the other available record case record, the largest session for observe that there is a primary passenger made to frame such in the present accused petitioner under section such as such. More so to frame any on the primary cases to be established. In present case, it is seen that there is primary method to frame against the present accused. Accordingly, I find the learned session for committed no error or mistake while framing as against the present petitioner under section of the law. Moreover, it is not supposed to conduct a mini trial as observed by Honorable High Court or Apex Court while dealing with the section under 482 CRPC. Now, if his argument, my lord, to consider the those deposition of the victim, who is yet to be considered by the trial court, my lord, is amount to, my lord, frame for mini trial, my lord. Therefore, my lord, there is the learned court, my lord. Trial court find that there is a case for trial, my lord, trial started. And until and there is any perversity, my lord, in the death order, my lord will not interfere based on the deposition, my lord, of the victim, my lord. That yet to be considered trial court, my lord.
When your deposition is not established any case
Pardon, my lord.
for trial, when your statements
Yes.
doesn't disclose any offense as alleged, then what's the use of trial?
No, well, that way, my lord. My humble understanding, my lord, whether this material is there or not, my lord. At this state, my lord cannot look into those statements, my lord, because my lord is to authority, my lord, to consider those statements with the trial court, my lord. Now, under 482, my lord, if suppose today, my lord, allowing this petition, my lord, that will make redundant the whole trial and whole appeal provision, my lord. Under if he find any in the meat of the trial, my lord, and on the meat of the trial, my lord, on the basis of statement, my lord, if my lord invoke 482, my lord, I humbly understand that will make redundant whole other provision of the statute. That cannot be, my lord. That's why I'm relying on this judgment, my lord.
The judgment which you relied on,
My lord.
the law, principle of law you are relying,
My lord.
it's well established and we're conscious of it.
Pardon, my lord.
The principle of law which you are relying,
My lord.
we're conscious of it.
Yes, my lord. That's it, my lord. Yes, my lord. But then also, but then I'm placing this matter, vigilance of this matter. Because my humble understanding, my lord, he's heavily relying on the deposition, my lord. If deposition, my lord, in the 482, my lord. Yes, during the appeal, my lord, that can be a matter to be looked into by this honorable comment. But in 482, my lord, how can those statements are recorded by the trial court, my lord? And trial court yet to apply his mind on those evidence, my lord, can be looked into by this honorable comment under 482, my lord. And if that is allowed, my lord, that will make whole other provision redundant, my lord. Here is a case, my lord, in the SAS order, my lord, if the learned trial court had discussed whole the judgment relied by him, my lord. All this judgment placed by today also placed by this council, my lord. But that has been discussed, my lord. And after discussing, he find it not that he'll be convicted, but he said there is a prima facie case, my lord. And for framing a charge, my lord, only prima facie to put into a person, to put a person in the trial, only prima facie material issues. That is there in the charge sheet, my lord. According to charge of frame, my lord. So I find there is no perversity in the charge, my lord, and this, my lord, petition, my lord, cannot be, my lord.
Please, Your Lordship. Lordship, in fact, having gone through the record, Your Lordship, I do concede with my learned counsel for the petitioner, Your Lordship. And with regard to 482, Your Lordship, this judgment does not specify as to the power under 482. However, this is a similar case whereby the apex court, while dealing with a case of promise to marry, had in fact made an observation that the High Court ought to have invoked its power under 482 for quashing, Your Lordship. If I may take, Your Lordship, to the second page, paras 6 and 7, Your Lordship. If I may read, Your Lordship. This court in a Katina of judgment has held that mere fact that physical relations were established pursuant to a promise to marriage will not amount to a rape in every case. In order for the offense of rape to be made out, two conditions need to be satisfied. That the promise of marriage was made by the accused solely with a view to obtain consent for sexual relations without having any intention of fulfilling said promise from the very beginning, and that the false promise of marriage has a direct bearing on the prosecutrix giving her consent for sexual relations. From a perusal of the record, it is clear that this was a case of consensual relationship from the beginning. Even if the case of a prosecutrix is accepted, it does not appear that the initial promise to marry was in bad fact. It was only subsequent circumstances that prevented fulfillment of alleged false promise to marry. Resultantly, the relationship turned sour, which has given rise to the present FIR. Further, in view of the material on record, we do not see this as a case where provision of pursuant. Hence, the entire criminal proceeding initiated against the appellant are nothing but an abuse of the process of law. In our opinion, the High Court should have exercised its inherent power under Section 482 of the Code of Criminal Procedure. Even in this case, Your Lordship will see that on the initial period of time, they felt both the parties had consented to live together, Your Lordship. Subsequently, due to sour in their relationship, the relationship of both the parties felt sour, Your Lordship, and thereafter, having not married, the petitioner filed an FIR against the accused herein, Your Lordship, for rape. Even in the present case, Your Lordship will see that as has been pointed out in the deposition, Your Lordship, they have been living together for a year since 2017 for 1.5 years, Your Lordship. Subsequently, as given in the statement itself, Your Lordship, that due to some differences, Your Lordship, the relationship could not continue, Your Lordship. That's when this FIR was filed. Also, taking into consideration that the deposition does not speak about any of the physical relationship as stated, Your Lordship, by the learned counsel for the petitioner, Your Lordship.
So
There is-
according to you, the trial will be futile.
Yes, in
The
terms,
breach
in
of the
terms of,
process of law,
yes, Your Lordship, in
the
terms
trial
of,
allows to go.
in terms of 376 as well as 417, Your Lordship. However, with regard to 427 and 506, Your Lordship, there seems to be an ingredients with regard to these two particular sections. But then in terms of promise to marriage, Your Lordship,
It's very clear.
there is nothing as such in the deposition nor in the report.
That's small. My lord is not exercising division of jurisdiction. That argument is my lord totally.
Yeah, that's
482 abuse of process of court. Lordship can exercise that 482 at any stage. And even if my lord not admitting, even if my lord the deposition is not taken in turn, only on the basis of the FIR also my lord the judgment covers.
Other relevant materials can be considered.
Yeah.
Whether there is a privacy case for 376 or 4717. That can be considered.
482 clearly says for abuse of
Your
process of
only
court.
submission is that only merely on the basis of the deposition of the victim or the prosecutrix, the 482 cannot be exercised. No power can be exercised under 482. That's your submission.
The sense of any capacity in going out in the south of the
I have not gone into detail. I just did not use the word pervert. That does not mean it is not perverse. Because on the, what is the material, my lord? The two depositions, my lord. The 161 statement and the FIR, my lord. What does it mean by that?
And Mr. That's all.
Yes.
Deepagi, learned counsel for the petition. And Mr. No, Mr. And also her MS. TJ learned additional people published and Mr. As well as Mr. L. Permit, learned counsel for the respondent number 2. Respondent number 2. Charge sheet. All.
Yeah, charge sheet and,
FIR also.
yes. Not the FIR, my lord, the charter.
Charge or no. Charge sheet. Section 6, 417, 427, 106. IPC. In Sessions case number 12 of 2022. Corresponding to Kano PS case, daily PS case, no 7/7/2019.
Matter number 45.
Yes.
My lord, this revision petition is filed against the order dated, my lord, 8/1/2024, part entitled money suit number 37. What happened is, in this case, my lord, there is a compensation amount for their land was acquired, and accordingly compensation amount was granted by the government. And there is a dispute between the two clans, the Jendu and Jampen clan. Is called one society, this Sari society. Both clan, common community is called Sari community, my lord. In the year 2019, my lord, there is a suit filed by the same plaintiff along with others that was withdrawn on compromise near Lok Adalat. So accordingly, it was decided to pay the apportionment of the compensation at the ratio of 60/40. We have also agreed. Then again, there is an agreement made with the Sadi society with the plaintiff for payment of rupees 20 lakhs.
Who is plaintiff? You are plaintiff.
No, I am the defendant.
Okay.
I am the defendant. Respondent is the plaintiff.
Hmm.
Out of which, my lord, 6 lakhs has been paid, or 4 lakhs has been paid. Now he is claiming a suit for recovery of 16 lakhs. And simultaneously, one more suit was filed. There is suit number 38. This present suit is against, present revision is against suit number 37. Simultaneously, in the same day, one more suit is filed. This plaintiff, along with the others member of the Sajis or Jampen clan, other clan members. That suit was withdrawn on compromise, and he is also a party in at that suit number 38.
And in respect of the same issue.
Same issue. In respect of the same issue. Now this suit is filed. He personally, individually, he filed this suit for recovery of 16 lakhs. The contention is that there is a agreement on 19/12/2020 between the defendants and the plaintiff. My lord, this start from my lord fact, this agreement is my lord page 27 is the agreement. Based on this, my lord, the suit was filed. The first this date of agreement is made on 19 December 2020 between the program Janpen contesting that team candidate and passing Janpen. Passing Janpen is the plaintiff. Now, my lord, his main contention is condition number 1. The Sajid Society, Zendu and Jampen shall pay 20 lakhs to Tasing Jampen from the compensation amount of 38 Anchor Highway Road. This is a compensation amount. And against this, the suit is filed. And the simultaneous suit, this another suit, this page, second suit is page 41.
Suit is filed for payment or recovery or payment
For-
of 14 lakhs. It's 16
16
lakhs
lakhs, the recovery of 16
because
lakhs.
of this,
Yes,
as per
compensation.
this agreement.
Yes.
Okay.
The
Yeah.
amount is, my lord, important is compensation amount. The amount is 20 lakhs. Which is, he said he's entitled for compensation for the acquisition of land. In the second suit also, my lord, this page 41 is restored. The here, my lord, plaintiff is the plaintiff number 29 in this suit. This was withdrawn on compromise and mutually settled. The same amount is claiming in the two suits. One in the present suit and another was withdrawn.
So what's the bar?
No, my lord, bar is, my lord, for the same amount, they cannot claim, my lord. We raised, there should be one suit.
Is it been withdrawn?
That has been withdrawn subsequently. Now, my lord, we have approached the High Court, then it was compromised. That was in summary suit. Now it was settled. Whether it is the same money he has got or not, that information we don't know, my lord, at present. But it is the same amount.
Yes.
Same amount here also, he has paragraph 3 on what he stated. There is 60% of the compensation. Therefore, we raise in question before the maintainability of the suit before the learned trial court on the 3 issues. The issue your lordship may find in page 71. Page 71. Down in the bottom. Whether the suit is paid for non-joiner of necessary party as part order 1 rule 10 SCPC. Whether the suit is part by resolution as part section 10 SCPC, whether the suit is liable to be related, no cause of action as per order 7 rule 11 of CPC. First issue was that, my lord, this whatever amount liable to be paid to the plaintiff is the society, Sajid Society. Sajid Society is not a party here in the suit. That's why we say this is not in the general party, appropriate party is Sajid Society. Suppose tomorrow decree will pass, then who will pay the money? It is the society, it is the member of community, it is a combination of clan members.
Money is with whom?
Money which is with us. Accordingly, amicable settlement was done, that was already been settled. Payment was made to most of the members. That
Why not all the members?
my lord, there is more than 31, more than 37 members, I think. 71, 70. There is a clan members. They have also beneficiary to that. They have got their share. That's why we paid before the learned trial court, my lord, this suit is not, already suit is, they have in group as the members of the society have already filed the suit that was reviewed. Subsequently, simultaneously, both suit was going on. One is summary suit, one is money suit. Summary suit is also for recovery of the same compensation amount.
Yes.
Yes. And the finding of the learned court below, my lord, is said,
Yes.
page 75. Page 75, my lord, further. Further, from paragraph 6 of the plain, the plaintiff has pleaded that the amount was apportionate between the Chandu clan and Jampen clan at a rate of 10 lakhs each. The defendant number 2 on behalf of Chandu clan had paid for 4 lakhs in consequence to the agreement dated 9/12/2020 to the plaintiff. Though the remaining amount 6 lakhs was denied to be paid to the plaintiff, stating clearly that the plaintiff is not maintaining cordial relations with the defendant. Thus, considering the factual aspect as discussed, also from the resolution dated 2/5/26/2022 of the annexed plain, what is transparent is that there seems to be implied consent of Saji society. So, defendant number 1 and 2 had agreed to pay an amount of this 20 lakhs to the plaintiff. Since both defendant 1 and 2 are the Jampen and Jandu clan, respectively, the combined Jandu and Jampen clan is a society. But society is not party.
They said it's not a registered society.
It's
Has
not
no,
a registered
it's
society.
not a
If
legal
this-
entity.
Yeah,
But it's been represented by different number 2 and 1 and 2.
my lord, if it is not registered society, it is, of course, it is not a registered society, admittedly. If it is a not registered society, the representative suit is like, order notice.
There is
which
no-
suit.
Only represented by 1 and 2. Dependent 1 and 2.
But for that, there is this procedure, my lord. But
Yes.
this is the finding of the first issue. The second, this cause of action is there. Next issue is paragraph 76 finding. I'm only reading the relevant portion. While considering a plan for altered under Order 7 Rule 11, consider a plan for reject. It must be crystal clear the reading of the plan is the whole, not disclose cause of action from the contents in the plan it is part by law. This must obvious in the face of unequivocal and reject of plan cannot be done in summarized comment. If there is a room of doubt, then it must be resolved in favor of sustaining the plan rather than rejecting it. Then the last paragraph, 77 bottom line. As discussed is following paragraph, though defendant 1 and 2 Saji society has agreed to pay the amount 20 to the plaintiff in consequence with the agreement dated 19/12/2020 was executed. In person to the agreement, the decision had made payment of 4 lakhs. However, remaining payment has been denied for violation of the other terms of the agreement. Defendant number 2, on the other hand, had not made any payment as per the agreement. Further, ongoing the replica is transparent that the plaintiff agreed to be paid 20 for the rule to immediate between the Jendu clan and the Jampen clan of the society. Since both the defendants has failed to pay the promise, as such, there is a actionable claim against the defendant. Thus, my consider to that claim cannot be rejected for no cause of action under Order 7/11 CPC. Both issues are decided in favor of the plaintiff against the defendant. Now, my lord, issue number 2 is I have said, my lord, 2 suits simultaneously filed. It is not maintainable. Needless to say, the issue framed in the person needs to be decided by way of evidence to ultimately prove by the party on whose honors lies. Honors of these issues are on the defendants. It is also significant to mention that in the replication, the plaintiff had denied the relevant periods of the written statement. There is a reiterated defendant had to bring this case within the ambit of Section 10. Section 10 deals with the stay of suit in case where the other suit is directly or substantially on the same matter in issue has already been pending in another court between the same parties and same title. Defendant in the action of pleading of the similar suit, money suit number 38 is being pursued simultaneously by the plaintiff before this court. The issue involved both the suits are one and no evidence is needed to substantiate the pleading or any will be sought for calling for the report to substantiate the pleading. Thus, the absence of record of money suit number 38, 2023 on record of this court, the court cannot adjudicate on the applicability of this section. Whereas it is admitted by them, they have also not denied this suit is not finished. The suit is he is the plaintiff number 29. His son is the plaintiff number 30 in suit number 38.
That has been closed. Withdrawn.
That has been up. No, it was recently closed. At the time of filing suit, it was not closed. It was recently, I think 1 month before it was closed. Before it was not closed. That's why we spread, my lord, this suit is not maintainable because it is a same suit already closed and they have withdrawn. It was compromised between the party. Suit number 37. 38.
When this matter was taken up, the suit number 38 was there.
Yes, it was there. Suit number 30 was, though both suits are listed on the same day before the learned court.
And that's in the absence record of money suit number 38. of
Yeah,
court.
but it was listed on the same
Court cannot agree on. Yes.
between the same party.
Hmm.
Yeah, only difference is here he is claiming 29 in individual capacity, and there also he is claiming 20 lots on the community as a whole. They are claiming more than 6 crore as the clan members, but the compensation amount is same amount for 2 suit. That's why we say 1 suit is right, the other suit is not.
Suppose if they don't find this present suit, but they pursue the suit number 38, what would be your stand?
That is the summary suit. 1 suit you can contest, but there is 2 suit. That suit was also contested by us, but ultimately we all the clan members, both the party have resolved. This come to an amicable settlement.
Therefore, this has been withdrawn.
It was withdrawn.
Suit
Suit was withdrawn. It was CRP was filed before the court, withdraw, and subsequently that suit was that's 1 month before.
Same issue.
Same issue.
Recovery of 20 lakhs.
20 lakhs. Same issue. They have in the page, suit number 38 also is start from there are 38. Same page 48 onward. Same thing. The only difference is there is a separate agreement of 20 lakhs with the plaintiff. There, the component, this apportionment is 60-40 between the society plan. 2 plan dispute between the 2 plans. But amount is apportionment of amount is against each person is 20 lakhs. That is the claim. Claim amount of all the members. And that should number 30. Here is here also 20 lakhs. Claim amount. Against the same compensation amount. That's why my humble prayer is that two suit cannot be like for the same cause of action.
By flux of time, there's only one suit now.
Now after just 1 month before it was withdrawn.
So
It was compromised, but yes, man, that is also interesting, man. Suppose if the main issue has already been settled, amicably settled amongst the member, there also the compensation amount is 20 against the same compensation amount. If this suit was run now, because main suit was already withdrawn and it was amicably settled.
we give settled what? For what?
For payment of the compensation.
Have you, it has been paid?
No, it
Has
was
it been
not.
paid? Has it been paid?
To my informal instruction, my lord, it was paid to the members. Some receipt are there. It was paid through check, I think.
But not to the plaintiff.
To the plaintiff, I don't know, my lord. To the clan members, because it was paid because of that, it was settled. Amicably.
Including the plaintiff.
Including, he is also member of that suit. He is plaintiff number 29.
Money has been dispersed
Yeah, it was disbursed by the government
to all,
to
to
the
the,
account of the society. The dependent number 2 or dependent number 1 and 2.
yes, so have you got the money?
Malad, now after compromise, definitely we got the share. Malad, the matter is totally different. Malad, my brother's project is totally different from the reality. Malad. What happened? These two suits are totally
No, just wait, just wait. Have you
My lord,
completed?
same. Kindly see, my lord, prayer.
It's okay. You say, you are saying that same. Yes.
Yes, my lord, he admitted prayer up page 29, my lord. Kindly see page 29.
Hmm.
Page 18, 19.
Of what? Petition
Petition
19.
19.
Yes.
Last paragraph, my lord, last 2 lines. It is categorically
This is the
that
plaint,
this is a plain copy of the plain.
37. Present.
Yes,
pending.
present suit.
Yes. Page 19. Yes.
Yes, my lord, yes, start from paragraph 4, page 18. Paragraph 4,
Hmm.
there is same that after amicable settlement.
40%. Wait.
Paragraph 5, page 19. Same suit, the same amount.
Yes. Then
Then this paragraph 5 is the last 2 lines, man. Paragraph 5.
hmm.
It the last 3 lines. It is categorically stated that the Saji Society, Jendu and Jampen shall pay 20 lakh
Next to plenty from the compensation amount of
shall be
Tata
compensation amount. my lord.
Huh?
This is the compensation amount.
Huh.
The other suit is also for compensation, same compensation. Tagedadi to Hankar Highway Road. Other suit is also same. my lord.
No, this. This. Suggest society shall pay rupees 220 lakhs to the plaintiff. And you have paid 4 lakhs. Right?
Yes.
Now, you have apportioned 10 lakhs each. Then accordingly, you paid rupees 4 lakhs. Remaining 6 lakhs, they are claiming.
That is the what money is that, my lord? That money is against the highway compensation amount. The second suit is also, my lord, kindly see, it's page 54, paragraph 14.
Why 16 lakhs?
4 lakhs. has
No, no,
paid,
4 lakhs has
4 lakhs I already received.
Then why you said 6 lakhs?
16 lakhs, 16.
No, para 6 you
But from one of the parties, my lord, I will receive 4 lakhs. So I will receive another 6 lakhs from him. And the another defendant, I will receive 10 lakhs.
Why you have to receive?
For my lord, there was a client,
Compensation was in the name of this society.
no,
Clan, community,
Huh? That's what I'm saying.
Saji community.
Saji community.
yes. Gentu and Genpen clan, there was clash between the parties, my lord. Therefore, the present plaintiff, my lord, he settled the dispute between the parties. Therefore, they promised that they will, from the compensation amount, they will pay me 20 lakhs for the settling of the case between the parties. Therefore, that agreement.
How do I pay money for settlement of that matter, my lord?
Hmm?
Is his share for compensation amount.
Hmm.
Is a compensation amount. The whole amount what is dispute between the two clan members is against the compensation amount,
Hmm.
land compensation
Yes.
for acquisition of highway
Hmm.
for that. Therefore, my lord, second suit also, my lord, same.
No, second suit.
Yes.
This agreement to promise or whatever agreement to pay 20 lakhs.
Yes. This clearly
is
stated, my lord.
about the suits.
Yes. No, it's not only 1 minute, but because a lot of confusion being created.
No.
That's the, it's only given only 2 minutes. I will
No,
explain.
what I have understood from him is that the division, he is not disputing that the 20 lakhs has to be paid.
Yes.
Right?
Yes.
Accordingly, suit was filed. The division withdrawn after the compromise or settlement.
No, but
This is what he's trying to say.
that's
Now,
not-
you cannot file a subsequent or simultaneous suit
Yes.
claiming on the same
Yes.
amount which has already been settled. This is what he's trying to say.
That's time out of the court. It's totally
Okay, then what is the fact?
What happened, Lord, the compensation amount, the land companies belongs to the community. What happened, those land compensation amount was withdrawn by two defendants on. None of the beneficiaries.
One and two.
Yes,
Defendant number 1 and 2.
yes. They,
Behalf of the society. Plan.
yes.
Yes.
On behalf of society, the entire amount was taken by these two people.
Ah,
So the another suit which had 31 people which have filed, this was a suit claiming the 6 crores amount which they have taken, this defendant number 1 and 2. For that, this suit was filed. And this particular 20 lakhs is a suit filed against these two defendants for an agreement which they have signed to pay this particular pay individually. The other 31 which has been withdrawn, that is by the household, all the household. They have filed this suit. This is totally for compensation amount which they have taken on behalf of the village.
respect of same land.
Yes,
Same land.
yes.
Then what amount you are claiming?
In that we claims more 6 crore.
Ah,
Yes,
that has been settled,
yes,
including you.
yes.
Now, what is this 20 lakhs comes for?
20 lakhs is for a logical see the agreement which they have signed.
Huh. What is saying that it's a part of, what is this agreement?
Agreement is saying that they will for settling the dispute between Gendu and Genpin clan.
Huh?
Yes.
This 20 lakhs is a part of the compensation only. That is what he's saying.
No, there's totally different.
Agreement made on solution between Sri Bogam Jempen contesting BJP JPM. Is Bogam Jempen is respondent number?
One.
A dependent one.
Yes.
And Tasing Jempen. You are Tasing Jempen.
Two.
Is Sajid you self-pay rupees to Tasing Jempen from the compensation amount that Sade Dege to Hooker highway road. Huh?
This agreement is between the defendant and me alone, but not other beneficiaries. This is an individual agreement.
But this
But
is the Saji Society. Who is Saji Society?
They are represented by these two people, man.
Huh? Jendo and Jempen.
Yes.
It's a society.
It's a society.
Society not
Consists of communities. How many members?
More than 71 members. I think.
no, because it's not registered, so we don't know count of members also.
No, he's right. In that case, you will have to have a representative capacity. You will have to.
Yes.
Dependent has to be in representative capacity.
The present
Not directly that he's also a member, you just make them. Because your basis is this. It doesn't say that Bogam Jumper and so and so shall pay. It says Saji Society.
on behalf of
I know they.
on behalf of such a society, man.
Huh?
Not registered society, but
So therefore, representative capacity will have to be
therefore
there.
they have signed, man. Logical thanks, find their name.
Hmm.
That's been signed by them.
So what for you are claiming? What for the society has to pay to you separately 20 lakhs?
When this land compensation was going on, man, competition was going on. There was a fight between the Gendu and Genpen clan. Man.
Huh. Yes.
So the plaintiff, discussing Pujan, he's settled the dispute between them. Therefore, they said, because you have settled such a huge dispute between the clans, therefore, the 20 lakhs would be paid.
Okay.
That's the
But then you have you as a Jampan thing. I mean, member of this society. You yourself also as a member of this society, Saji Society. So you have got your share of compensation.
this was promised by these two people, man.
That's what I'm saying.
They received the compensation amount. That's why.
No, that's why. But that has been ultimately the entire compensation has been settled now among all the members, including you.
No. That's a different, totally different.
No, that's what I'm asking.
Yes.
That compensation amount has been settled, right?
Yes.
You have also received your share of your share.
I hope so, but some share would be received, man. Because it was distributed equally to the villages.
Now the agreement this is talks about 20 payment of 20 lakhs to you from the compensation amount. Where does it says that it has to be paid to you because that you have already you have settled the matter
Yes.
as a, I mean, cost or whatever,
Yes.
you have been paid. So you have to be paid. It doesn't indicate that. It's only says that from the compensation amount.
That all those definitely in matter of trial before the court below. Now, clause see just page 29 months.
Yes.
This is the resolution which they took.
Before the letter with
That's it.
we have any same passage. See, Tashi Gentle on account of failure or violation of presumed regulation. What is condition number 5?
Condition number 10.
Bogam and Japan still maintain, you have not
Like,
maintained relation.
now what they say, they are not maintaining important relations, so we'll not pay the rest of 6 lakhs amount.
Okay.
This is the reason. Well, anyhow, well, all these things has to be settled by the court below only, during the trial. But as a prima facie, no any case is made out for revision by this on. The learned trial court has elaborately discussed every issue which they have raised.
But then one thing,
Let's have
one
fun.
thing, when there's, it doesn't say the trial court has not said that the suit number 38 is a different
Yes.
cause of action. It simply says that it's not before him, therefore cannot be considered.
Yeah.
It was pending.
It was pending. Yeah.
After the trial court, it is for the person who files the petition to.
You fight out in the trial court.
My lord.
He'll not get anything.
Yes, my lord. Court-
Ultimately, he'll not get anything.
You will not get it.
You fight it out.
Because he is damaging his suit own by him.
Therefore, you fight it out.
The objection which they have raised has been already discussed.
Let trial go on.
Yeah, my lord,
All right.
it should be a my lord, representative suit.
let's
But
try-
all those things we can raise, the objection which has been raised has been dealt by the court.
Yeah, that's why.
This was not raised by him
Hmm.
during the court episode.
You raise all this thing on facts.
Yes, madam.
Of course, it is true, my lord.
You raise that. Yes. He'll not succeed,
Yes.
perhaps. So you fight out there. It's a good case for trial for,
Yes.
which is in your favor.
My lord,
See,
necessarily.
His resolution, I'm just indicating. The claim, the basis of the claim is the agreement. There's a conditions that you have taken a resolution that you will not pay now because he has violated the clause, condition number 5. His basis in condition number 1, clause number 1, and your refusal to pay the balance amount of 6 lakhs is condition number 5.
Defendant number 2 says that because you have violated the terms and
Yes.
conditions of agreement, we would not pay the remaining 6 lakhs.
Yes. So else, or else you pay 1 lakh, 50-50 more.
That is the same amount, my lord. The India content, page 54. There is a higher compensation amount.
No. Now it's matter is very clear now.
Yeah.
The compensation, there's a, chaos or whatever problem with the compensation amounts. You have received the amount, different number 1 and 2,
Was received
on behalf of this thing. So there's a complaint and whatever problem was there. So ultimately, there was a suit and that has been settled, it has been withdrawn. That agreement has been, that the settlement is over. So far as the, general compensation which you have accepted. Now his basis, this only basis is that during all this thing, there was an agreement that he will be paid 20 lakhs. Out of 20 lakhs, you have paid 4 lakhs. Now, according to you have the basis that since there's an agreement, you have failed to, honor this agreement.
Yes.
He's seeking recovery of 20 lakhs. Whether it is, legally is entitled or not, that will be looked into. Is not it? Now you are saying that you will not pay rest of the amount, 6 lakhs, as promised. As agreed, because he has violated
Terms and conditions.
whatever condition. So it's a good case, fight it out. Yes.
It will take that.
Otherwise,
Because they are from Manigaon.
Huh?
To travel to Allo.
No, it's not. That is procedural hazards or, what do we call it? But that cannot be a ground for interference.
rich people, they took all the compensation amount now after filing a
But
suit.
you have already received the compensation. Why you are
I've been told, madam.
this you are seeking your recovery. You are seeking recovery of the amount is also out of the compensation. From where they'll make.
I'm told, madam.
Once it is settled.
I'm told because I filed the suit, that's why they didn't pay me, madam, for the compensation amount as on date.
They've rightly done it.
If you pay, then it is amount to admitting.
You have not been paid.
No,
You have not get your share.
no.
No, no, in the
The
settlement,
common share. I
common
didn't get.
settlement. You have not.
I've been told just because I filed the suit, that's why they.
The
You
same
should
amount,
give it.
no, my lord, same amount to suit, my lord.
No, whether
So that,
whether he has been paid or not, his share.
no, his share not paying because pendency of this suit.
Has he got any share?
No.
Is he entitled for any compensation?
Yes.
Yes, he's claiming for that, my lord, this suit number 38,
Huh?
suit number 38.
Yes, that has been
The
decided.
same amount he is also claiming, my lord.
Now this amount is totally agreement.
Same amount, my lord.
That amount is general.
No, same amount, there is a land compensation amount.
What is share P50?
CRP 50 is arising out of that suit, my lord, suit number 38.
38. That has been closed.
Yes.
It was closed, disposed of
Ah.
on the road.
So,
Madam, I wouldn't bother your lordship, otherwise citation and all that, madam.
no, what do you say?
How about there, my lord, this order name is the fact they, whatever they are, they get you, get a share from the suit number 38.
No, we're not.
Due to
Well,
pendency of this. suit,
no, that I'm not,
Because he is claiming double.
sir, I'm not convinced to that. According to you, it's a same suit, same issue,
Same issue.
same cause of action,
Yeah.
which has been withdrawn and settled. I'm not convinced to that. Whether he's entitled, he has the legally, enforceable or whatever to get the recovery of this amount, that there is a separate. That settlement compensation is something different.
But the amount is same. No, amount
Maybe
of-
amount may be same, but the basis of the claim is different.
In another suit, we are claiming 6 crore, more than 6 crore, 50 lakhs, madam. Here I'm claiming, individually claiming 20 lakhs. That's totally different suit.
My friend has given clear calculation, page number 54, my lord. How do you get 20 lakhs? This line. So all the calculation was given.
But that's totally different, madam.
That's it.
It's not same.
Yes. Disposable of merit. Yes.
Lordship,
Anything
citation, my lordship,
you just heard Mr. S.K. Devri, learned counsel for the petitioner. And also heard Mr. T. Tapo, P. Tapo. P. Tapo, learned counsel for the respondents. This revision petition. Has been filed. No, this revision petition is preferred against the order dated 08/01/2024, passed by the civil judge, senior division,
Yes.
civil judge, senior division, Western District. What is that, Intune order?
It's not, my lord. Page 67 on Annex 6.
8-1.
wherever the objection raised by the petitioners in Manishut, Manishut number 37 of 2023 with regard to non-gender of necessary parties and
Yeah, three issues are there, page
Ah.
71.
you just say, tell us.
Non-gender of necessary party or also barred by register. Same.
Res sub judice.
Subsidies.
71.
Yes.
With regards to the non-gender of necessary parties. And barred by res subjudice. Have been rejected. Mr. What's the order?
Apply. Sir.
This is what, 2017?
Yes, ma'am. This is
Para?
regarding the powers to be exercised under one
Para two,
revision.
para,
Para
14.
14 minutes.
The first protection is over the experience on the ground of the.
Strongly,
Cases of illegal irregularities in the this exceeding open to the parents of that city.